Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Thank you for being with us today. We have argument today in 4 cases. Our tentative plan, at least, is that we will take a short break after the second case and then return. And we will hear argument first in Jonathan R. versus Morrissey. And Ms. Wellickson, hear from you. Whenever you're ready.
Thank you. Good morning, Your Honors. My name is Laura Wellickson, and I represent a certified class of over 6,000 West Virginia foster children who, as the district court acknowledged, suffered the same shocking neglect by the state that its foster care system was designed to redress. This appeal is about the power of federal courts to address unconstitutional conditions so pervasive that only system-wide relief can correct them. The district court's decision that federal courts lack that authority must be reversed for 3 reasons. First, the decision squarely conflicts with well-established precedent confirming federal courts have the authority to order system-wide relief. Second, the district court misapplied threshold standing for redressability, which is easily satisfied here. Third, the district court prematurely resolved concerns about the scope of the remedy before liability was established.
Well, let me ask you this. Can federal courts, if an injunction is issued, direct the state to expend funds necessary to effect its injunctive directive?
Now, the spending of state funds for prospective compliance is absolutely permissible under the Constitution, Your Honor. The Supreme Court has said that multiple times, including in Milliken.
So is there any sovereign immunity issue?
Under Milliken, there is no sovereign immunity issue. If the systemic deficiency, that is the constitutional violation, is under-resourcing and budgetary shortfalls, then that is the root cause of the harm to plaintiffs, then the remedy can go to that harm. Now, in Brown v. Plata, the Supreme Court, in fact, clearly articulated that. It said that when unconstitutional conditions are caused by things like chronic understaffing, what West Virginia has, budget shortfalls, a general lack of political will to enact reform, then a court can issue those types of remedies, and in fact, a comprehensive injunction with a multifaceted approach aimed at many causes will only yield the effective solution. When the state takes custody of a child, it assumes an affirmative constitutional duty for the child's safety and general well-being, as this court recognized in Doe versus South Carolina Department of Social Services. When the state government, over the course of years, systematically fails to comply with its duty to protect these children, federal courts, when called upon, have responsibilities to step in and remedy those constitutional violations. And once invoked, the scope of federal equity power is inherently broad and flexible. The Supreme Court has said that numerous times in Swan, in Milliken, and of course in Brown v. Board of Education too.
Can I ask you a question that might go to sort of the first thing you said when you laid out 3 errors? Because I am just struggling a little bit with how exactly to conceptualize the problem from your perspective that you are identifying. Is it that the district court conflated standing with the merits that for redressability, you're supposed to assume a favorable decision for the plaintiffs, and here the district court was assuming a unfavorable decision at the remedial stage? Or is the district court asking the right question? At standing, we ask whether the remedy was available and coming up with the wrong answer. Which way are you seeing the case?
Well, Your Honors, I think that the district court erred in both those ways. This court in Buscemi v. Bell clearly said that when determining the scope of a court's remedial power, we assume that a claim has legal merit. That is what the district court was obligated to do. And so the question is whether the district court can issue any injunctive relief, presuming that the constitutional violation and the violations of federal law are proven. And under binding precedent, the court can issue all of these remedies. In fact, these remedies have been issued in numerous cases, both in the child welfare context and outside of it. And as far as the concerns about the scope of the remedy, yes, I mean, he definitely conflated the standing for redressability, the threshold standing inquiry on redressability with end of case remedial concerns.
So at standing, you ask, is this kind of injunction categorically available? And then the remedy question is, this particular injunction, does it satisfy the limits in cases like Jenkins? Is that, you would split the inquiry into two like that?
Yes, Your Honor, and importantly, for the threshold standing test, you ask whether the court can issue any type of injunctive relief. If any kind of relief is available that will mitigate any part of the plaintiff's injuries, that is enough for redressability. As this court said in Sierra Club, the removal of even one obstacle to the exercise of one's rights, even if other barriers remain, is sufficient to show redressability. Now, the Supreme Court said, just as here in Diamond Alternative Energy, even $1 is enough to show the redressability requirement. And if you look at the prayer for relief, Your Honor, because there's a lot of discussion about the holistic reforms that plaintiffs are requesting, and we concede that we're requesting some holistic reform. But there are also numerous injunctions that are simply asking the court to enjoin the defendants to comply with existing federal law, their legal obligations. And it is beyond question that the court has the power to do that under Ex parte Young and numerous other cases. And as far as the holistic reforms, Brown 2 expressly stated that courts can remedy systematic constitutional violations in a, quote, systematic and effective manner. And of course, it bade the district courts on remand to do just that in fashioning comprehensive desegregation decrees. As I mentioned, in Brown v. Plata, the Supreme Court elaborated on some of the type of systemic issues that can yield the need for comprehensive injunctions. Things like chronic understaffing, chronic resourcing, the same things that the district court here found in its decision on appeal. It says that the foster care system has cycled through inaction, bureaucratic indifference, shocking neglect, and temporary fixes for years. The court said the blame squarely lies with the West Virginia state government. And it charged the legislature, the governor, and the governor's appointees for failing to do their job to protect West Virginia foster children. Now, these conclusions should have galvanized the district court to step in and remedy the problem. Instead, the district court cited them to justify abdicating its
It
responsibility.
certainly cuts against your argument to remand to a different judge, doesn't it? That the court really did seem to understand the argument and be doing diligent work to get to the bottom of the issues. But then you say, because of the standing ruling, that we should send it to a different judge. I was having a hard time reconciling that.
Respectfully, Your Honor, I disagree that there is a conflict. because although the district court said all of those things, it immediately then said that the answer for the plaintiffs is the ballot box. How can that be if the political branches have failed?
But isn't that you say that's an erroneous legal ruling, and if the three of us agree, then we can send it back and say, well, that was erroneous as a matter of law, move on with the merits. But we do that all the time without requiring a new judge.
And we understand, Your Honor, that reassignment is an unusual remedy that, that we don't request in all cases. I think that the problem here and why we're asking for reassignment is that the district court not only grossly erred, it ignored binding precedent, but it was also very open about its long-held beliefs that not only were these remedies unconstitutional, but that they also were ineffective. He espoused deep skepticism with this type of remedial relief.
But let me ask you two questions in that context. Now, Judge Goodman's a long-time federal judge, and I have some reservation about removing him because I believe that he could follow instructions if we give them. If he doesn't, then we can do something else. But to that end, insofar as establishing a record, was he within his discretion to dismiss the case sua sponte, and has he done anything else where he has abused his discretion? You might disagree with his ruling, but from a pure legal standpoint, did he have a right to do it sua sponte, and has he abused his discretion in any other manner, other than you disagree with his philosophy, I guess I would say?
Well, ultimately, it is this court's decision whether or not to ask for reassignment, whether or not to reassign the case. It was not within his discretion to dismiss the case. This is a de novo review, and again, binding precedent dictates the outcome here. Now, you have no choice but to reverse under binding precedent, both of the Supreme Court and this court. And again, I don't want to overstate the issue, but the district court ignored all of those authorities. Now, it cited some law review articles, a handful of dissents, and cherry-picked some quotations taken out of context from inapposite authorities. Now, one example, for example, and I mean, I do disagree with him on this, but it is his view, that these are issues that are better left to the political arena. And he cited National Federation of Ministers versus Sibelius.
But this court's decision, if we agreed with you at this point, that it's not his philosophy about it's better to do it at the ballot box. He would be directed by this court to do what you're asking, or at least to consider it.
Our concern, Your Honor, and I want to go to the standard for reassignment, which is, it's not in this circuit about just personal bias or animus. The standard for reassignment is whether it is advisable to the potential difficulty the judge might have in putting aside previously expressed views. It is to preserve the appearance of justice. And that standard is met here based on the statements of the district court in its own decision. The statements of the district court express deep skepticism about the remedies, both their propriety and their efficacy, and he telegraphed that he would, as he did in the class certification decision, which he also cited, he telegraphed that he was going to be very, unwilling to grant the relief that plaintiffs request.
So is that a reason for us to reassign it? That seems to counsel against reassigning it, is that you've kind of forecasted how you think this judge views the merits if we send it back on the merits, and you'd like someone who doesn't view it that way.
we see that as the reason that we're requesting reassignment.
Yeah, you'd like a different judge who agrees with your sort of theory of the case. But if we send it back and say you were wrong on standing, we're going to remove you because plaintiffs, disagree with how they think you're going to come out on the merits in this bench trial, that seems to set a pretty bad precedent.
Respectfully, Your Honor, we do not need a judge who's going to agree with us. We want an impartial tribunal. And
Is there any reason to question his impartiality? I have not seen one.
I do not want to impugn his impartiality. And again, this is for the judge, for you, Your Honors, to decide. It is absolutely within your discretion to determine whether to reassign the case. There is indication, though, there is a statement that the district court made that indicates that he is in some way predetermining the merits. He said, this is not a case of a discrete constitutional violation that calls for a narrowly tailored remedy. How can he know that without going through a trial? So those are the types. Well,
because you're bringing these very large amorphous class claims. Do you want to talk about the class certification at all before your 2 minutes are up?
I'm happy to, Your Honor. We see the cross appeal as essentially a last-ditch effort to avoid accountability for the state's systemic failures. The class certification decision is evaluated under an abuse of discretion and clearly erroneous standard, and the state does not even come close to satisfying that. And the district court certified the class because the central legal question in this case, whether West Virginia foster children face an unreasonable risk of harm from the state's practices, was a common question that could be proven on a class-wide basis.
Am I right, the general class is all children currently in foster care and all children who will ever be in foster care in West Virginia? Is that right?
Your Honor, I would actually have to double check that. I know it's all children who are currently in foster care. I don't know about the future component.
I think it's the children who are or will be in foster care. And I just had questions about how these questions are common to all of those children. Even the certification order pointed out children who, the court certified the class, but at the same time seemed to be identifying children who didn't have these common questions. Like one is chronic understaffing, right, high caseloads. And the court pointed out in only 8 districts in West Virginia are the caseloads within, acceptable levels. So my question obviously is then, well, the children in those 8 districts, it's not a common question for them, right? Whether understaffing is creating this risk of harm. Is it?
Well, for one thing, there are other problems.
Is that a
than
common
understaffing.
question for those children?
Absolutely, Your Honor. And
How?
The reason for that, well, first of all, if 2/3 of the districts are understaffed, that creates a huge pressure on the system. And in fact, in West Virginia, caseworkers get reassigned. They get taken from one place to another. They also routinely quit. There has been high turnover. And so you never know whether you're going to have enough caseworkers. And as a general rule, there aren't enough.
But we're supposed to be asking, there's supposed to be a question that's common to every member of the class, right? That this question, and we will get a common answer that will resolve something important with respect to each class member, not just, well, it's a big problem that affects a lot of members, but it has to be each member. So how does the understaffing common question give us an important answer for children in districts that aren't understaffed?
The common question analysis, Your Honor, focuses on the claim and the core injury that is being asserted, which is
those children are not injured, right? If they are not subjected to the understaffing.
Oh, we disagree, Your Honor. They are absolutely injured. It's a holistic deficiency in the system. Because, and let me also tell you, say that it's not just understaffing, right? There are
but the court identified 3 common questions for the general class, and one of them is understaffing.
Correct.
So we just have to deal with what we have. That's one of them. How is that common to children who are in districts that aren't understaffed?
Well, because the core legal injury is risk of harm.
Yeah, are those children at risk from understaffing if their district is not understaffed?
Absolutely, because that district may be understaffed at any imminent moment in the future, as many of them are. Just because, and this is a hypothetical, because most of the time, I think most of the districts are understaffed, but just because one district happens to have enough staff in that moment, doesn't mean that a month later, 2 will have quit. Now, 1 will go on medical leave, and that they will be understaffed. That is how risk of harm works. And
That seems to suggest maybe the class should be defined as, children in districts that are, currently or will be understaffed, right? The same problem comes up with the case planning. The court identified, statistics and said, only 19% of families say that they were actively involved in the case planning. And so then the question obviously arises, well, as to that 19% of families and children, how is the failure to involve families in case planning a common question for them?
because those failures are repetitive and they may happen at any time in the child's time in foster care.
But that's like asking us to imagine something that we have no evidence of.
Well, a common question doesn't necessitate a common answer.
It
right?
does. That's exactly what Walmart was about, that it's not just common questions. It's that a common answer will move the case along for each member of the class.
Well, the common answer is whether, as a whole, these things can be litigated and brought to, yes, ultimately a common answer. I think one of the, maybe what, Your Honor, you might be having difficulty with is the distinction between the risk of harm and the actual manifest harms, the cascading negative impacts in each child's life.
Well, if we were to agree with you and send it back, we don't have to reach that question now, do we?
Your Honor, nobody is, I don't think the state is asking for a remand on class certification. I think the court can decide, to, of its own accord, can answer this question. I mean, again.
Can I ask you, so why, I have questions about whether we should be reaching the class certification question at all. There was no 23F certification in this case. I don't really understand how you can take a cross appeal from class certification. You can only appeal a judgment, and class certification is not a judgment. That's the whole reason we have 23F. So I'm actually a little perplexed as to why we would reach that issue in this context, and I'm wondering if you have thoughts about that.
We were a little perplexed as well why there was this conditional cross appeal. We analyzed whether we could move to strike it. My understanding is that because—
Did you move to strike it?
No, we did not, Your Honor.
Is it jurisdictional, or is it waivable by the opposing party?
I'm not sure, Your Honor. I think the reason why we didn't move to strike is because it's our understanding that in a final judgment, everything is contained within that final judgment, and theoretically you could, they could have a second bite at the apple, and—
Yeah, but if, we have to reach standing first, and if this court agrees with, this is a conditional cross appeal, it kind of only springs into being if we first agree that there was standing, the district court erred, and this case is going forward. At that point, this would be an interlocutory review of a class certification decision, right?
Yeah, I think that's correct, Your Honor, and that doesn't seem proper to me, to your question. I just want to say one more thing about—
What would be gained by sending it back for a trial on these classes and then having another appeal where you give us these same briefs and these same arguments about class certification? Isn't it, what's the efficiency gain there if we don't decide it now and wait to decide it later?
I don't think that there's an efficiency gain if you assume that the class certification was wrongly decided, or that it might be. We strongly maintain that class certification was well within the bounds of the abuse of discretion standard. First, it's not about whether this court would have come to its own conclusion that might be different. It's about whether the findings were clearly erroneous and whether there was an abuse of discretion. And it's worth mentioning that every court that has addressed a foster care class action across the country has certified the class. Now, the district court relied on numerous precedents, and the reason is because these children are in the custody of the state, and these system-wide practices don't just impact a discrete part of the state. They are system-wide.
What is the practice, like when it comes to having an insufficient number of foster homes? What is the state practice that has caused that? What is the practice you're challenging?
Yeah, well, one of the common questions was an insufficient array and number of foster homes. I mean, there are a number of practices that are bound up in that. The state doesn't do enough to recruit foster families. It doesn't.
So the court identified the array as the practice, the sort of state of affairs. There's an insufficient number, but I didn't see the court identifying a common practice that you were challenging that led to that state of affairs.
Well, the practice, it was, I think, array in number and type. And so the practice is having a chronic deficiency in the number of available placements for children, which causes them to stuff children into any placement that they can possibly find, many of which are inappropriate. And we interpret the array question in that certified question to be all of the inappropriate places where these children are placed. Things like offices, without even proper beds.
Well, the state says that they had evidence to present that this is not a practice, that this is something they're trying to solve and fix. It's not, in any way something that they are, that they have intended or that is the policy of West Virginia DHS, but that the district court wouldn't consider that evidence because it went to the merits.
And we think the district court was correct in saying that it went to the merits. There was substantial evidence that there is a drastic shortage of foster care placements and that children are in inappropriate placements where they are not safe and where their needs aren't being met. So that evidence is there. What the state is doing about it, you could call remedial efforts. And remedial efforts, if anything, are a question of mootness, right? They don't moot the claim unless...
Well, I mean, saying that there's evidence that there's not enough placements is like saying, there's evidence that something is going wrong, but to say there's some common practice that's affecting everyone, you have to identify the practice, the pattern, the policy, the thing behind it that is the same for everyone and is affecting everyone in a certain way. And that seems to be tough to identify here.
Well, I think we're getting into the minute particulars that would be litigated at trial. When we talk about the deficiency in foster homes, the shortage, I mean, what goes into that the state is not doing or is doing are things like they're not paying foster families enough. They're not providing enough support and services for people to want to be a foster placement. They don't support foster. They don't provide enough services to foster parents. I mean, there are innumerable things that they are not doing that they should be doing. They are essentially chronically under budgeting, under resourcing, understaffing the system such that their practices, their omissions contribute to these deficiencies across the system.
All right, thanks so much for your time, and you've still got some time on rebuttal.
Thank you very much, Your Honors.
And Mr. Williams, we'll hear from you.
Good morning, Your Honors. May it please the court, Michael Williams for the state defendants. 2 days ago, this court reiterated that a plaintiff does not have standing when his or her requested relief would, quote, have the federal court act beyond its proper role in a system of separated powers and dual sovereignty with the states. In dismissing plaintiff's suit for lack of standing here, the district court merely recognized and respected that unobjectionable principle. In particular, it found that the sweeping relief that plaintiffs seek would require the district court to effectively take control of the operations of a state executive department. And perhaps worse still, plaintiffs had not shown that this takeover would actually remedy the injuries that plaintiffs purport to identify.
Well, that case, unless I'm missing something, was about states suing the federal government over restoring federal employees. I mean, that makes no sense at all. I mean, what's that got to do with this case? I mean, you're talking about federal employees, the state defending or representing federal employees suing the federal government. I agree with you. I guess it was Judge Wilkins that wrote that, but I don't see the analogy between that case and this case.
So Your Honor's correct that the ultimate holding concerned a suit against the federal government by the state of Maryland. What I will say is that in reaching that holding, the court identified several instances in which a particular injury may not be redressable. And one of those instances was when a federal court is asked to do what plaintiffs are asking the district court to do here, which is reach into the affairs of a particular state executive department.
No, maybe I'm misunderstanding. What that suit is engaged is diving into the affairs of the federal government. It's the reverse.
That's correct as to the holding, Your Honor. But in the course of reaching that holding, Judge Wilkinson laid out several instances in which a federal court may determine that an injury is in fact unredressable. And in that list of instances, one of the things that Judge Wilkinson identified is exactly what the district court identified here.
I certainly wouldn't want to criticize Judge Wilkinson, but some of that opinion goes beyond what the issue was in that case.
Well, that's fair, Your Honor, but I think it still is a reflection of well-established law. So if that's a concern that you think it was beyond the holding, what I would point you to, for instance, the Shepard v. Morrissey decision, which does specifically concern the effort of a court to reach into the affairs of a state executive.
Well, do you disagree that there, since post-Milligan, that federal courts have exercised, with approval of the Supreme Court, intervention where a persistent constitutional violation has occurred, such as in prisons or in schools? I mean, do you agree that that's happened?
The state recognizes that that has happened. However, there are still limits on the ability of the federal courts to exercise that power. And I think the desegregation cases recognize that, the prison context recognizes that, and I think ultimately the district court simply recognized those limits and applied them to the context here.
And I don't disagree with you. I mean, there are limits to what we ought to be able to do. I don't disagree, but to get in the door, you would have to agree that federal courts have that right.
The state does not quibble with the notion that a plaintiff may bring a federal constitutional claim. But I think there's space between the plaintiff's conception of the standing inquiry and the state defendant's conception of the standing inquiry is they seem to perceive the remedies question as solely confined to the end of the case.
Well, this kind of goes to the question Judge Harris asked earlier, I think, is, I mean, this question for standing and redressability is just, can the court grant any effectual relief?
Correct.
Do you agree with that?
We do.
So the question is not, does the court have the power to grant plaintiffs swing for the fences remedy? That's not the question at standing, right?
Well, I would say that it is a question of the, what I'll take your words as the swing for the fences remedy, when that is the sole remedy which they pursue. And what I would say
Why
is...
is that true? I feel like district courts always, even if, let me imagine hypothetically, the plaintiffs are asking for nothing but swing for the fences, district courts narrow those at the remedial phase of the case. I don't understand how we absorb that inquiry. Is this particular injunction tailored properly under Jenkins? I mean, that's what the courts are for, the district court will apply Jenkins and all those other cases at the end of this and tailor the injunction accordingly.
So there is a scope of remedy issue at the end of the case. We don't quibble with that either. But what we would say is that you have to look to the nature of the claims that are being brought and then accordingly measure the remedy that they perceive to actually
But aren't you
redress
supposed to
the
look
claim.
at the violation and tailor the injunction to the violation? I thought that was really important. You don't tailor it to the claims that are being brought. You tailor it to the claims after there's been a trial and some violations have been proven. That's why I don't understand how you can do the tailoring before the trial.
And so perhaps I'm just being loose with my language, and I apologize for that. I think what you have to tailor it to is the constitutional asserted injury and harm. The court has said that redressability is really meant to mirror the injury to the remedy.
That's been proven at trial.
Well, no, Your Honor. Diamond Alternative, one of their preferred authorities, specifically talks about, even at the pleading stage, that the remedy that they seek needs to mirror the scope of relief that they're asking for. And I think if you look at the claims, and in fact, this court characterized some of those claims before in Jonathan R1, in this
I mean,
court's...
you must, sorry,
Sure.
this is a little semantic point.
No, please.
I assume if the plaintiffs have made a claim and you prevail at trial that it is not true, you will not then tell the district court you should tailor the injunction to the claim and not the verdict.
Your Honor, and maybe this is, I think, where we're two ships passing in the night. I think the way we perceive it, and we're basically taking plaintiffs at their word. I'm looking at J 247, for instance, when they're actually characterizing what they want and what they're asking for and what they perceive their claim to be. They perceive their claim to be a unified, singular, intermingled violation. To the extent, and actually you heard some of that same language this morning, to the extent that they're characterizing it as comprehensive. I think she characterized it as a holistic injury. These things all operate together in their mind. So if they can't, for instance, parse out 30 individual remedial orders, because that wouldn't actually address how they at least have pled and asserted this particular claim and this particular harm. And again, this court itself characterized their assertions as, quote, wide-reaching, intertwined, and systemic failures.
Is this from our first
From
opinion?
your first opinion
And
at
then we said,
336.
if I'm remembering right, and it's premature to consider the scope of the remedy that's being sought at this threshold time, and that will be a question at the remedial phase. I mean, we said that.
You absolutely said that, Your Honor, in the context of abstention. We do not quibble with that at all either. But what the court didn't say is that you have to strip out any concern about remedy at all until they actually get to trial, because frankly, I think that would create serious jurisdictional concerns. The district court would then be in a position where it's essentially issuing an advisory opinion because it doesn't know if it's ultimately going to be able to actually offer any relief to the plaintiffs before it. If it really can't offer anything, then a finding on liability gets them nowhere other than an advisory opinion, which is, of course, exactly what the district court can't offer them. So in other words, by pushing these claims that are wide-reaching, intertwined, systemic, their remedy is concomitantly wide-reaching, systemic, and broad. And trying to peel out individual elements of relief just doesn't work and isn't consistent with what plaintiffs themselves have actually asserted. So I think the district court correctly recognized that remedies of that sort are a serious concern because they require expansive judicial administration of
They
executive
have to be
functions.
more than a serious concern for this to work at redressability. They have to be per se, you can't do it.
And Your Honor, again, is keeping me to my precise language. It is per se improper.
What's the best case for it is per se impermissible for a district court to issue, I'm going to try to quote, but I'll get it wrong.
Sure.
Like wide-ranging systemic relief.
I want to be frank with Your Honor that there's not
Okay.
one single case, but I
Okay.
think that concepts that you have to follow from cases like Missouri v. Jenkins, Horn v. Flores, these cases all provide principles that the district court appropriately applied here, where it found the three distinct problems of intervention into the inner workings of an executive function, the usurpation of core state functions, not just the control of the purse, which Judge Floyd has already mentioned, but actually control of the purse in a context of child welfare. But in addition, making express public policy determinations and taking options off the table to address what are admittedly serious societal and social problems in West Virginia. And that confluence of circumstances is what left the district court concluding it had no authority to order the relief that plaintiffs sought.
But that's not the question. It has to have no authority to do any relief, and I totally disagree. Sorry.
It's
I
okay.
totally agree with you. The district court didn't say that. The district court said, I can't issue this injunction.
Any relief necessarily has to be tied to the plaintiff's claims. And again, I would say a district court, for instance, can't say, boy, I'm really concerned by the child welfare problem in West Virginia. And I think a good step towards the right direction personally would be if I order the department to implement some new specific policy that I think is going to be great and is going to really help children. That's not what they brought to the court. The court can only respond to the claims that are brought before it, and ultimately that's what the district court did. So, given that, I think...
One of the examples she gave, I don't know whether this is right or not, but she said that one of the things they were trying to, relief they were trying to get was to have West Virginia comply with federal law in that area. Now, I don't know what she's talking about, but let's assume that you're not complying with some federal statute with regard to children. Could she not obtain relief for that?
Again, it would depend on what they're asking for, because a follow-the-law injunction, courts are extremely skeptical of.
Well, isn't that
So-
why we have a have a trial?
Well, no, Your Honor, because, again, I feel like I'm just, I'm circling the same point, and I apologize for that. But I
That's
think
okay.
if there's no remedy at all, then that becomes a problem of addressability. If the court says, I think there's something I can do for you, but I'm not sure what it is yet, that becomes the sort of scope of remedy problem that I think is appropriately addressed at the time of trial. I completely agree with that idea. But if the court looks at the claims before it, and what they say is required to remediate and redress and produce a likely resolution, which is the standard for redressability of the claimed injury, if they look at that and say there is nothing that I think will meet that level, then yes, I think the court does have a threshold responsibility to say, I can't do that for
Can I
you.
ask you a question? Wouldn't it have been both more customary and more productive if the district court had given the plaintiff some notice about what it was thinking about here and maybe had a hearing or gotten briefing? It seemed very unusual to me, just given, this is brought to mind by the conversation we are having.
Right.
This seems like it would have been useful to involve the parties and particularly the plaintiffs if this is where the district court was headed.
So
Do you have views on that?
I think the state defendants would concede that this is not customary. What I would say is that the particular special context of this case provides less reason for concern. This was, of course, a case that had been, Your Honors are familiar with this case. It's a case that's been winding its way through for several years now. There's been several submissions that go to these exact questions. The district court had flagged its concern with the
Yeah, but
problem
it
before us.
flagged it and said, and that's something I'll get to later.
And I think-
I mean, I feel if anything, it's sort of put the plaintiffs on the opposite of notice. It said, I've got issues, but we'll deal with that down the road.
Well-
I feel like it's
Certainly.
kind of bait and switch to then all of a sudden say, never mind, I'm actually going to do it as a dismissal.
So I guess if the court had just kind of popped up out of nowhere and said, by the way, I'm dismissing on standing, that might be one thing. But I think it's important to remember the context of the pending summary judgment motion. And in that pending summary judgment motion, state defendants had, not to use the dangerous word, but identified some of these issues with redressability. And I think at that point, that's what motions do. They serve to put the party on notice that they need to be aware of a problem that they need to identify and address before the court. And so, having failed to do that, I think the district court appropriately said, well, you know, they've now mounted their whole summary judgment record. They now know the issue. They know from before it was an issue for me. They know now it's an issue for the state defendants. So I'm ready to move forward. And I think in that context, I think there isn't at least reversible error there in choosing to sua sponte. As of course, I think as Judge Floyd mentioned, a district court does have a right to sua sponte address standing. So I will just briefly comment, I see the yellow light is on, but I'll briefly comment on a lack of injury in fact as well. We recognize, of course, that this is not an issue that was addressed by the district court, but it is a jurisdictional issue that the court has a responsibility to address on its own, even if the district court did not. And some of the discussion I think that we've been having today also goes to that same injury in fact problem, that plaintiffs have oftentimes focused on sort of a risk of a kind of ambiguously defined harm that's in some way tied to a due process or an ADA claim. And respectfully, that's just not enough. There needs to be a certainly impending, identifiably concrete injury. And as much as the state of West Virginia and the state defendants recognize that there are serious problems in the system, to say that there are serious problems in the system is not to say that there are constitutionally cognizable injuries that actually sustain a complaint here. So that's all we note on that issue. We think it's in some ways tied in with redressability. Again, they are in some ways mirrors of one another. But that's ultimately a problem as well.
Can I ask you this question about your class? Can we review your appeal for class certification, given that it's outside the procedures prescribed by Rule 23F?
So we recognize this is something of an open question, Your Honor. This court, I believe, has one case in which a party did what we did here, where they conditionally cross-appealed, and the court sort of in its discretion said we choose not to address it, we're going to send it back. It didn't suggest there was some sort of jurisdictional problem. It didn't suggest that the rule barred it. We are aware of authority in other circuits. I believe the Seventh Circuit in particular actually counsels parties to do what we did here, which is if you're bringing, if you're on appeal and you have a problem with class certification, raise your hand now and speak up, perhaps because of some of the efficiency concerns that Judge Rushing was identifying.
So how hot an issue is that with you?
How hot an issue? It's very hot, Your Honor. I would say that if the court allows this case to proceed, it absolutely should remain.
But I guess,
Please.
remand on the class certification?
Yes, sorry if I misheard you, but if the court does allow the case to proceed and put aside the standing issues, then we would ask that you remand with instructions to decertify the class.
I mean, a class certification, that can be changed any time, right? I mean, I think one of the
Yes.
efficiency reasons behind 23F is why should we pass on it when the district court could still change it? I mean, maybe some of these remedial concerns that the district court has flagged will make it think that it also should narrow the class.
So I think here, Your Honor, it would be especially appropriate to go ahead and address the issue because of the serious problem with commonality. That's an issue that doesn't necessarily, I mean, I suppose a lack of a common issue will, of course, create problems when it comes to the remedy for the class as well, but it's not sort of tied up or necessarily nested into those remedial issues that the court would be addressing on the standing side. And we, as we explained, Walmart, we think, very clearly requires an actual common policy or practice that drives a common answer. And searching through this record, we simply can't find one. What we instead see are a series of allegedly disparate failures, and if anything, a series of uncommon practices, policies, and even disparate effects. And this court has been very careful to say that, especially post-Walmart, that's simply not enough. And I think some of the colloquy that you heard, for instance, on caseloads is one of the reasons why we think that's so. Different members of the class are being affected by these supposedly different common policies in different ways, and that alone is enough to say that it's not actually a common policy that satisfies the commonality element of 23b2. I think there are other aspects of what the
Can I just ask, I'm sorry, just about the procedural posture again. Was there, given all of that, is there a reason you did not pursue 23F review of the class certification decision?
Here, Your Honor?
Mm-hmm.
So we did not earlier pursue 23F.
Right. Oh, yes, that's what I meant, at the time of the certification. Yeah.
Understood. Candidly, Your Honor, I don't know.
Okay.
Yeah, but what I can say now is that, at least with our view of the present record, we think that there are glaring abuses of discretion based both on sort of a legal misconception about what the nature of a common policy or practice is, as well as the court's responsibility in conducting the rigorous analysis. We think the district court was inappropriately afraid, I think, to engage with issues that might have touched on the merits because he misunderstood and thought that those were sort of verboten, when Comcast and other cases make it clear that they are not. And he inappropriately engaged with some of the evidence, and in particular, didn't take note of evidence that showed that these policies continued to evolve and continued to work in sort of inconsistent ways that undermine a finding of commonality.
Can I ask one more procedural
Please.
question? Judge Harris's good points have made me wonder, would we need to go through our sort of typical 23F analysis before deciding to decide?
Right.
Your cross appeal, you know, the rule doesn't have requirements, but in the case law, you know, we go through, consider a few factors. Would we need to do that now, or is there no need for that because we have a final judgment of some sort?
Well, three things, Your Honor. I would say, one, no court that I'm aware of has undertaken that kind of analysis in this sort of unusual posture. Two, I think that what plaintiffs suggested as to the sort of every prior order being sucked into that final judgment does to some extent hold here. And three, I think it is relevant that I haven't heard any suggestion that that standard is applicable or necessary to be met by plaintiffs. So I think it's not a jurisdictional rule as far as I'm aware. So that could, of course, be waived by plaintiffs, and we believe has been waived by
This
plaintiffs.
is such a tricky issue, I think, because, I mean, it is jurisdictional that had you not gone through 23F and just noted an appeal from the class certification at the time
Right.
of the certification, we would not have had jurisdiction to consider that appeal, right? It's a,
Well, that would be.
that's Cooper's
right,
and
there's-
Librand,
there's
right?
no-
Right,
Right, there's no, correct.
right. So, I mean,
Yeah, w-
this
we-
seems at least quasi-jurisdictional. There's a jurisdictional thread in here somewhere. I confess, I
think
am
I've heard
actually
it
very
sometimes called-
confused by this question.
Right,
but
jurisdictional characteristics or jurisdictional
Yeah.
flavor sometimes, but I would still say that.
That at this point, because there was a final judgment, we're out of
That
jurisdiction.
opens the door into the appellate court, I would say.
Is there an answer to this question that keeps confounding me? When you take an appeal, it's supposed to be from a judgment, but you're appealing a class action. Your cross appeal is of the class action certification order. That's not a judgment. So how can you take an appeal from it?
It is, Your Honor. I would say that the way the rule conceives it is that we can sort of target the underlying order by way of the judgment, and I think that's why we do
Okay.
term it a conditional cross appeal. It does sort of spring back into life in that sense.
But
But
it does, when it springs back, it's now
Does it then
interlocutory.
And I think there has not been a court that has said that.
The Ninth Circuit pretty much did, but it was a long time ago.
Yeah, maybe I
It was
misremembered.
23F, so it may
I
not
was
be
going to
that.
say, I
Yeah.
think more recently, I think the Ninth Circuit is one of the circuits that does tend to hear these now, unless I'm mistaken. So,
Okay.
yeah.
Tricky.
I recognize it is a tricky issue. However, I think particularly given plaintiffs not raising many of these issues, I think the court would be well positioned to address these important questions, especially because I guess I see the red light is on, so I'll just briefly end by saying it does go to some degree to the ultimate complexity of the final injury and remedy and all that based on what class we're looking at. I mean, that's going to shape those decisions if the court finds that there is some issue with the district court standing analysis. So, thank you.
Thank you.
Hello again, Your Honors. I want to just address a few of the points that counsel made. You know, he's in their 28J letters, right? And you were having some discussion about that, the Maryland versus USDA opinion and the Shepard opinion. They're all examples of the simple redressability question that the Supreme Court stated in Diamond Alternative Energy. What are the primary goals of redressability? Is to ensure that the plaintiffs do not sue the wrong parties and that the courts don't issue advisory opinions. So in Maryland, we had the wrong plaintiffs. In Shepard, they were the wrong defendants. What you need is a sufficient nexus between the relief requested and the plaintiff's injury. And we clearly have that. It's comparable to what this court held was sufficient for redressability in Shenandoah Valley Juvenile Center, where it said that the harm was the constitutionally inadequate system of care. It was affecting the plaintiffs who were juvenile detainees in a detention center. And the relief requested was addressed at that harm because they were seeking a trauma-informed standard of care. That is enough. And what is also enough is that we're entitled to any kind of injunctive relief. There's all this talk about the scope. We are in so many of the specific components of the prayer of relief, we're asking for compliance with existing legal obligations under the Adoption Assistance and Child Welfare Act, under West Virginia state law.
I didn't think you had a federal statutory claim anymore. District Court reduced it to the Substantive Due Process and the ADA and Rehab Act claims, right? Not the one you just mentioned?
Well, that is correct, Your Honor. We do have an ADA claim.
Right, sorry. Those federal statutes, you have an ADA and Rehab Act.
We don't have an AQUA claim. I think what my point more largely is that the types of legal violations are indicative of a constitutionally inadequate system of care. So whether or not we have an existing AQUA claim, these are all deficiencies in the system that are related to the chronic under-resourcing of the system. I want to turn briefly to the class cert issue, because one thing is setting aside the fact that it seems like you may not even want to reach that question for procedural issues. If you do, you were asking a lot of questions about, how do you parse the injury? And I think it's important to remember that the risk of harm is inseparable. It's unitary. And in Brown v. Plata, I see my time is up. May I just quickly conclude? Thank you. Brown v. Plata is an example of a class certification of the entire California prison system. And one of the issues was chronic understaffing, which the Supreme Court said was one of the causes of harm. And the court did not ask...
I don't think the Supreme Court reviewed the class cert, did they? They reviewed the remedy,
I think, yeah.
which ordered release of thousands of California prisoners.
That's correct, Your Honor. The class was already certified. But throughout the class certification process, and to my knowledge, in the class cert decisions that we've briefed and that our opposing counsel has briefed, no court has ever asked whether one particular district is sufficiently staffed where others aren't, or 2/3 aren't. In one.
It's kind of like Walmart, right? Where there's, you can say, well, Walmart baked into its promotion policies discretion, right? And this discretion is exposing all women to a risk that their manager won't promote them because of discrimination, right? But the court said that sort of thing is not enough. It has to be the policy itself is actually affecting each woman, right? There's a common question to every member of the class. And if you define it at a high enough level of abstraction, everyone works for this company, so it might happen to them. That's not enough.
Respectfully, Your Honor, I don't think we have a Walmart problem. The Walmart case is distinguishable. There were Title VII claims there, and the plaintiff's theory of the case was that managers exercised discretion and that there was no official policy that their discretion should be cabined. That is the opposite of what we have here. We have our theory of the case is that there are mandated standards that the state is not complying with as a whole. The caseworkers are not visiting children even once a month, as they are required to do by state law, and that those deficiencies, those failings, are all caused by systemic problems, not just chronic understaffing, but also inadequate case planning as a whole, also an insufficient infrastructure for community-based services that are forcing children into institutions. So I see my time is up. I hope I've answered your questions. Thank you.
Yeah.
I think I'm limited on rebuttal to class certification, so I'll limit myself to just two things on that score. One, I think the last thing that you just heard is very important for class certification purposes, which is that I think plaintiffs are confusing common injuries, common problems, common issues with a common practice or policy. And it's the common practice or policy that then drives the common answer, and that's what you have to find for purposes of commonality. That's what Walmart said. I think it really is a Walmart problem in that all of the women, for instance, who were suing in Walmart might have felt similar harms and that they were treated unfairly in the employment context because of their gender. But ultimately what the court said was that there just wasn't any evidence that would suffice for a rigorous analysis to show that Walmart was doing something that applied across the entire class that specifically caused those injuries. And that to me is the fatal flaw.
Can I ask you just a quick question?
Please.
I think I understand your Walmart argument. Just looking at the case law out there, it is the case that many very similar-looking class actions in the foster care context have been certified and approved on appeal. Would you say those cases were different, that those cases didn't have the same Walmart problem, or just that they are wrong, which is entirely, that's
Sure.
a legitimate argument?
I think that there are distinctions factually between those cases and this one. I think the way that we've heard plaintiffs frame this up, for instance, as one big holistic endeavor that's like a huge kind of singular universal remedy, I think is maybe different than, for instance, the Texas class action where I believe there were 60 distinct remedial orders, and they really kind of approached it more of like a rifle shot kind of approach for each particular injury. To the extent that there is a case out there, I'm not aware of it, that's on completely all fours and
Well,
respectful.
right, none of them will be
Right, of course.
identical, but they all
But-
seem to raise the same kind of
Sure.
Walmart issue.
Understood.
In every case, it's not like the policy says, let's understaff.
It-
It's just, yeah.
I think maybe there is one piece of evidence that the district court at least didn't identify, and I haven't heard plaintiffs identify, that some of those other cases do purport to identify, which is sort of a specific and deliberate intent or policy not to have a policy. Sort of we as a department make a choice specifically just to be indifferent to this issue, right? That is a much different question than I think the issue that we're being presented with here, which is there are common harms, but they result because of resource limitations, or they result from professional limitations, and I'm of course taking their allegations as true, but they result from all these sort of disparate causes, and I think that Walmart really raises the question of whether that's a sufficient common policy or practice. So I see my red light is on, so I'll let it go. Thank you.
Well, thank you very much. Although we usually come down to Greek Council, we're going to ask to shake things up and do it differently. If you guys wouldn't mind coming up here, we would like to shake your hands from the bench.
You could have gone down to this one. No, just 'cause
We will hear argument in our next case, number 241404, Mitchell Repair versus Evox Productions. Whenever you are ready, counsel.
Good morning, Your Honors. May it please the court. Here's a license agreement at the center of this copyright dispute. Mitchell One licensed images from Data One, who is a sub-licensor and broker of Evox. But Evox has asserted that Mitchell One infringed Evox's copyrights in the licensed images by exceeding the scope of the Data One Mitchell One license agreement. In the Data One Mitchell One license agreement, Data One warranted that it had all necessary rights in the licensed images to perform the agreement, and Data One agreed to hold Mitchell One harmless from a claim or suit by a third party to the agreement. And the Data One Mitchell One license agreement has a forum selection clause that mandates any disputes arising under the agreement shall be brought exclusively in Virginia. Now, there have been 2 forums in this litigation at the trial court level, and I'd like to discuss those forums. One of the forums was the Southern District of California. And I'll refer to that court as the California court. The other forum is the district court that we're appealing from, the Eastern District of Virginia, and I'll refer to them as the district court or the Virginia court. Turning to the California court, despite knowing about and reviewing the Data One Mitchell One license agreement, Evox filed suit for copyright infringement against Mitchell One in California without naming the necessary party, Data One. Mitchell One filed a motion to dismiss or alternatively transfer the California case due to Evox's failure to name Data One as a party. As the California court found, because Evox's copyright infringement claims arise under the Data One Mitchell One license agreement, Evox, quote, sued in the wrong district, end quote, and the California court transferred the case to Virginia. That's at JA 275.
So can I ask you why, or what is your position on whether that moots out this appeal? I mean, if the underlying controversy was around the venue for this suit, that seems like it's now been determined.
Well, Your Honor, we did file a motion to vacate the dismissal and remand, and we had a request for instructions to consolidate this case with the transferred case.
So is that because you think the appeal is moot?
We think the forum issue on the appeal is moot, but
Is there a forum issue on appeal? I thought the district court kind of very carefully avoided ruling on what the court didn't rule on the forum selection clause or any of that, because all of that was presented to the district court as a matter of Ninth Circuit law, California law. So the court, I don't see any question about what the proper forum is in this case. It was just a first to file ruling.
Well, Your Honor, there's only one forum in the litigation now. It's the Eastern District of Virginia. All the parties' disputes will be litigated there.
Right. I guess I'm wondering, why would we vacate what the district court did here when you'd have to prove the district court did something wrong, or that the question in front of us is moot, but the question in front of us is just, did the court correctly rule that the California case was filed first, and so defer to it?
So, Your Honor, there are errors in the district court's dismissal. There's errors in the district court's refusal to stay, and I can address those. But in the motion to vacate, this court, the resolution of the forum issue would no longer have a practical effect because the parties are in Virginia. And that was the core of our motion to vacate. But
Do you have a position on whether this appeal is moot?
so, Your Honor, the forum issue is moot. So I think the remedy is to vacate the dismissal and remand.
Why? I don't understand. We might vacate if we thought the appeal was moot, but why else would we vacate?
Well, so, Your Honor, this court's customary practice in the Omish case, for example, is to or vacate moot aspects of the lower court's judgment and remand. And so we think that's appropriate here. We don't think the case should be dismissed.
What aspect of the lower court's judgment is moot?
The dismissal, Your Honor.
Why?
It's no longer a live dispute where the forum is. So there was a default by Evox in the Virginia case. Data One had filed an answer. Evox defaulted. There's still legally cognizable interest in pending motions relating to the default. But the forum issue, that's what's moot. So I would submit it's not appropriate to dismiss the case, vacate with instructions to dismiss the case, but vacate to allow the parties to continue to litigate the remaining disputes.
Why don't we just affirm the district court's decision?
Well, Your Honor, the dismissal was erroneous, and I can address the merits. The district court erred by not giving controlling weight to the forum selection clause. The Supreme Court in Atlanta.
Can I ask, I don't understand, at the time the district court was ruling, Evox's position was, why this is not a controlling forum selection clause on us, we're not parties to the agreement. So, are you saying the district court was somehow, and that was the very issue being litigated in the California court, are you saying the district court was required to sort of accept as a given your position in that litigation, that Evox was bound by the forum selection clause?
Well,
How would it be error for the district court to say, I don't know, they're going to decide that in California?
well, Your Honor, the court erred in not giving controlling weight to the forum selection clause.
But it doesn't have to give it controlling weight. I mean, there's no argument that it would have to give it controlling weight if it didn't bind Evox.
Your Honor, it understood, but
Okay.
Evox is bound by the forum
Well,
selection
that's
clause.
what you say, but the district court doesn't have to rule based on your litigation position in the California litigation.
So
It
you're,
doesn't have to accept as the first premise that you are correct in your legal contentions and then take it from there.
Your Honor, in the complaint, we alleged that Data One and Evox are coordinating against Mitchell One, and that Evox is a third-party beneficiary of the license agreement. Those allegations are well pled and taken as true.
If an allegation of a legal conclusion doesn't bind a district court, if it did, litigation would be so swift and brisk, but that's not how it works.
Understood, Your Honor, but we're here on a sua sponte dismissal. We didn't have an opportunity to prove those allegations. We made the assertion in response to the show cause order that Evox was bound by the agreement, and now, you know,
Well, I saw you making the argument that as a matter of law in the Ninth Circuit, Evox is bound by the agreement. It was an argument about California and Ninth Circuit law. There was nothing about, you know, as a matter of the law in the Fourth Circuit, Evox is bound, and therefore the forum selection clause should be preeminent in your first file analysis. Even in our court, you don't really give us reasons why the Fourth Circuit law would counsel the court to hold that.
well, Your Honor, few points. We weren't limited to the Ninth Circuit law in our response to the show cause order. That was an eight-page order that we were limited to. We did cite briefing to the California court about why Evox was bound.
And the district court kind of quite sensibly took that to mean, you know, the California court is litigating this, and, you know, I'm going to defer to that and not interfere with that and let that court sort it out.
So, Your Honor, that was error. The court misapplied the first-to-file rule. The first-to-file rule does not override a mandatory and enforceable forum selection clause. And Data One was a necessary party and joined in the Virginia case, and there's no question they're bound by the forum selection clause. The district court correctly recognized Mitchell One's, quote, licensing agreements with Data One select Virginia as the proper forum for disputes arising from the two parties' contracts, but then did not give that forum selection clause controlling weight. Instead, the district court subordinated the forum selection clause in favor of the first-to-file rule. And this court has said the first-to-file rule is not unyielding, and the California action was not entitled to deference under the first-to-file rule because of the mandatory and enforceable forum selection clause that mandates Virginia forum for disputes arising under this license agreement. Now, the California court has ruled that Evox was bound by the agreement, and that's in the record as persuasive authority. But this district court's finding that Data One should be joined, now albeit it should be joined in California, but the district court's finding that Data One should be joined to Evox's copyright claims is a finding that Data One's a necessary party, and that implicates the forum selection clause. So,
Let me see if I understand. The Virginia District Court found that all the claims raised in the Virginia action could be asserted as affirmative defenses or as third-party claims against a necessary party in the California action also found that judicial economy would be served by having the entire litigation resolved in a single action rather than piecemeal. So how does the, what about that do you disagree with? Because what he did is decline to exercise declaratory jurisdiction. What's wrong with that?
So,
I mean, how is anybody harmed by what he put there?
so Mitchell 1 was harmed by not having its claims resolved in Virginia pursuant to the formal selection clause. You know, what the Supreme Court has said about form selection clauses in Atlantic Marine and in other cases makes sense that they serve vital interests of the justice system. If someone could just run off to a different forum and file suit, that would circumvent form selection clauses and undermine the freedom of contract. So here, the district court found, quote, no legitimate explanation for Mitchell's choice to file a separate suit for declaratory judgment in this district, and Mitchell's purpose must be to wrest the choice of forum from EVOX and interfere with the existing suit. So that's not applicable here because there was a forum selection clause mandating Virginia forum. And so,
Well, sure, it's applicable. There is already a lawsuit, and if you think the forum is wrong, you file a motion to transfer because they filed in the wrong forum. But the court's point was, we don't normally address this problem by filing, multiple lawsuits. We address it by requesting to transfer to the appropriate forum.
so Your Honor, we did file a motion to transfer in
Right.
California, and the court granted it. And before then, we filed in the correct forum with both necessary parties, Data One and EVOX, and we pled all our claims. And so Atlantic Marine and the other cases we cited do not require us to plead all our claims in the improper forum. And so we have EVOX filed in the wrong jurisdiction and defaulted in the proper jurisdiction, a correctly filed claim, and now is seeking to use the later transfer to avoid the consequences of its default. And so that's improper. And there were, not staying the case was erroneous for all the reasons that the district court erred in dismissing the case. If there are no further questions, I'll close by saying the court should grant Mitchell 1's motion to vacate the dismissal and remand with instructions to consolidate this case with the case transferred from the California court. And in the alternative, the court should reverse the district court's judgment and remand for further proceedings. I'd like to reserve the remainder of my time for rebuttal.
Thank you.
Good morning, and may it please the court. There are three reasons why the district court's decision to dismiss Mitchell 1's declaratory relief action in Virginia should be affirmed. I'd like to quickly cover just those three issues.
Sorry, I hate to cut you off, but before you tell us why it should be affirmed, I thought your position was that the appeal is moot and we don't have jurisdiction to rule on it.
No, the appeal is not moot,
You
and
didn't
that's
say
one
it
of
was
the
moot?
reasons that it should be affirmed. We say it was functionally mooted by the
Okay.
transfer, and there's a distinction, and I'll explain the distinction. And this is actually the third reason why the district court's decision should be affirmed. The court's order transferring the case to the Eastern District of Virginia does not moot whether the district court erred when properly declining in its discretion to not exercise jurisdiction over Mitchell 1's declaratory relief complaint, certainly as to EVOX. And there are three reasons why that is the case. The first is that the mere fact that Mitchell 1 and EVOX still dispute whether the district court properly exercised its discretion to dismiss Mitchell 1's declaratory relief complaint establishes that there is still a right case in controversy
No.
before this court.
No, the fact that two parties are still arguing about something doesn't mean that an appeal isn't moot, unless there's some effectual relief we can grant at this point.
The effectual relief that can be granted at this point is affirming the district court's decision. In other words, the parties still dispute whether the district court erred. We believe that the district court did not err and that the district court's judgment dismissing the declaratory relief case should be affirmed. Mitchell 1, on the other hand, says that the district court erred and that that judgment
But
should
what
be
practical
vacated.
difference for you, explain to me what practical difference it makes in the world at this point, whether we affirm the judgment or not, given that the case is going to be heard in Virginia?
The practical difference is that if the district court is reversed and the case is remanded back to the district court in Virginia, then the district court has two separate cases.
We can consolidate them
completely
if it wants.
overlapping
The
that would
district
have
court-
to be consolidated.
Okay.
Or have to, I'm sorry.
No, I just don't understand how whether the district court, how the district court manages its docket. I don't think that is enough to keep this appeal alive. Does it make a difference to the parties how we decide this case?
Yes, it makes a difference.
Okay,
to
tell me
EVOX.
how it makes a difference to you guys.
It makes a difference to EVOX because we think that the case that should go forward is not a declaratory relief action where EVOX is the defendant, but rather the transferred case from California, the copyright infringement case on the substantive merits that EVOX brought in California that was transferred to Virginia, where EVOX is the plaintiff, and Mitchell 1 is free to assert all of the affirmative defenses or even declaratory relief counterclaims that it brought in Virginia, and to add in Data 1 as a third-party plaintiff. But we don't think that it makes sense for EVOX to have to defend a declaratory judgment complaint and to as a defendant and prosecute a affirmative copyright case at the same time, and to try to help the district court figure out how to deal with both of those.
Sorry, just to summarize, you're saying the practical difference in the world, the relief that we can give is that your client can be a plaintiff and not be a defendant.
That is one of the reasons for not simply vacating this.
What
appeal
is that, I mean, what is the real, I don't really see the real practical relief we're granting there, how the world is changing.
Well, at
There's
trial-
effectual relief.
At trial, we would be going first, we would be presenting our
Right,
copyright
okay.
infringement
I do
claims.
understand the difference between a plaintiff and a defendant. I guess I should have clarified. Well, I'll just be frank. I thought your answer was going to be, we don't want a default judgment, and there's a chance the default judgment would be revived if you rule, if you vacate in this case, and we would like to avoid that has real, actual practical impact on my client, and that's why they're paying me to stand up here and not just, litigate this case in Virginia.
That is true as well. We don't want to have to litigate the default. Now, there was a clerk entry of default. The judge has not
Right.
entered default.
Right, there
So
were motions pending.
There were motions pending, the motions were briefed. We don't think that it makes sense to have to litigate that issue, litigate some of the other issues that were raised in the declaratory judgment case in the context of that case. There were several issues that Mitchell 1 raised in the context of its declaratory judgment case, including the default. And all of that, we don't think that there was any grounds for a default. We think that if we go back and have to litigate that case, that Mitchell 1 could never establish any prejudice, particularly after the year and a half or so that it's been since the district court entered its judgment dismissing that case. But that aside, yes, that is another practical effect that the district court will not have to deal with if this court simply affirms the district court. And we think that this court should affirm the district court because the district court was correct in exercising its discretion that under the first to file rule and under its inherent authority for considering declaratory relief claims, that the district court properly exercised its discretion and decided that before it addressed any of the issues that were raised, including the applicability of the forum selection clause to a non-party like EVOX, that it was a better course to allow the California court to decide those issues in the first instance. As you heard, there was already a motion pending in the California court to either dismiss the case or to transfer it to Virginia. The central issue on that was whether Data 1 should be joined, or the failure to not join Data 1 and the forum selection clause. And the district court determined that it was better to avoid inconsistent rulings, to interfere with what the California court was going to do, to allow the California court to decide that motion before the district court in Virginia kind of preempted all of it and decided that issue in the first instance. And so what the district court did under the first to file rule analysis was apply the first to file proper analysis under the Wenzel case. And the district court did that. The district court looked at all of the factors under Wenzel, including the similarities and overlap between the issues in California and in the Virginia declaratory relief case. It looked at the comparative progress between the two cases, and it did the Rule 1401 balancing that is required in the first to file analysis. And it came out deciding that in its discretion that the case should go forward in California at least until the motion to transfer to dismiss was heard before the district court interfered. That was a proper exercise of discretion under the first to file rule. And that's the issue on this appeal, on the substantive merits of the appeal, is whether the district court properly exercised its discretion to dismiss without prejudice. So the earlier filed California case could, and the judge in California could determine whether that case should be dismissed or transferred. The issue of this appeal is not, as Mitchell 1 has argued, whether EVOX is bound by the forum selection clause in the Mitchell 1 Data 1 license. Now, to be clear, we think that EVOX was not bound, but we understand that the court in California reached a different decision. We did not seek an interlocutory appeal of that decision. For the reason is a practical one. The court did not think that the case should be litigated there, and I don't want to litigate a case where a court thinks we shouldn't be. But the Virginia court did not need to decide that issue of binding, whether EVOX was bound, in order to decide whether it should exercise its discretion to let the California court go first in as opposed to exercising jurisdiction over the second filed duplicative declaratory judgment case that was already pending in California. And this court does not need to answer that question either to decide whether the district court properly exercised its jurisdiction in applying the first to file rule so that the California court could go first. So in applying the Wenzel factors, the court again reached a reasonable conclusion in determining that it was better not to risk the inconsistent rulings. Now in response, so the court issued a order to show cause. And in response to that order to show cause, Mitchell 1 never explained how the forum selection clause in the Mitchell 1 Data 1 license applied to EVOX or superseded the first to file rule as a matter of law. We think that affects a waiver of the argument. Mitchell 1 simply said, well, the Ninth Circuit law says that EVOX is bound, but never said what Ninth Circuit law or explained how that happened. But even if it's not a waiver, important point I think is that Mitchell 1 doesn't cite a single case to this court where a district court has been reversed for exercising its discretion to dismiss a second filed case under the first to file rule, whereas here, two things. One, the plaintiff in the first filed case was not itself a party to the contract with a forum selection clause. And second, the second filed case was a declaratory judgment action asserting only defenses to the first filed case. Not a single case that has reversed a district court exercising its discretion under the first to file rule under those two circumstances. So Mitchell 1 also argued.
Counsel, I think we understand your position, and you've got time. No, you don't have time. We understand your position, so I think we're set.
Thank you, Your Honor.
Your Honors, a few points on rebuttal. Like to discuss the motion to vacate. Appeal is not moot. We heard discussion about the pending motions related to the consequences of EVOC's default. Data One has answered in this case, and so to go back and replead all of that in a separate case is inefficient. And so the correct relief is vacate or reversal, and I'll focus on the merits and why reversal is appropriate. Data One is a necessary party to EVOC's copyright claims. That's what the district court found here, and that is where Data One is to be sued relating to the license agreement, is a Virginia forum. And there are also breach of warranty claims that Mitchell 1 filed in the declaratory judgment case that are unique to Data One and were never a part of the California case. The district court had no good reason under this court's case law to decline to exercise declaratory judgment jurisdiction given the presence of the forum selection clause and Data One being a necessary party. And
Well, let me ask you this. I'm having a hard time following this. Everybody's in Virginia now. All the issues are there. The only leg up that I can see is that issue of default. So why can't we just get in the car and drive to the courthouse and litigate it?
so, Your Honor, our motion did ask for a vacate of the dismissal, and there's still legally cognizable interest in the pending motions related to the default. And in addition, Data One's answer.
Well, I understand the default is the leg up issue, but you still got to litigate it.
Understood, but an affirmance by this court would wipe that out, and we would be with just the California case, and we would have to replead Data One, and Data One would have to re-answer, and then we would plead defenses.
How are you harmed by that default going away?
So,
In real terms, I'm a street fighter, lawyer, and judge. I mean, how are you harmed in the early stages of litigation when there's a fight over whether a default is going to stand or not? It's probably not.
Well, Your Honor, the district court should decide that motion for default judgment on the merits in the first instance. It was fully briefed, understood the standard is high, but instead the district court dismissed based on a misapplication of the first to file rule. There are cases in the blue brief and the gray brief that have confronted this issue of the interplay between the first to file rule and mandatory enforceable form selection clauses, and the first to file rule does not override form selection clauses. It's the other way around. First to file rule is subordinate to form selection clauses. And so, and I would like to point out that Mitchell 1 raised the enforceability of the form selection clause under just general law throughout the proceeding. We raised the form selection clause in the complaint at JA 9 to 10, 15 to 17, 20, 23, and 30. In the motions related to the default, JA 183, 215, 214, 222, 224, 145, 146, 199, and 205. And then in the response to the show cause order, we did reference Ninth Circuit law, but then at JA 243, we made the argument that EVOX's copyright claim is that we exceeded the scope of the Data One Mitchell 1 license agreement. But then how can they not be bound by the form selection clause in that same license agreement? That's picking and choosing parts of the contract you don't like. That's unfair, and that's contrary to the Supreme Court's guidance of enforcing forum selection clauses serving vital interests of the justice system. So for all these reasons, we would ask this court to vacate the dismissal and remand for further proceedings, or in the alternative, to reverse the district court's judgment and remand.
Thank you very much. If you wouldn't mind, we would be happy if you would come up, and we will greet you from the bench, and then we will take a short break.
This honorable court will take a brief recess. judges of the United States Court of Appeals for the Fourth Circuit.
All right, everyone please be seated. And we will move on with our third argument of the day. Number 24-1958, United States versus Richard Rund. And I think Mr. Kaufman, we'll hear from you first.
Good morning, Your Honors, and may it please the court. The district court erred by finding first that the Eighth Amendment's excessive fines prohibition doesn't apply to the willful FBAR penalty. Secondly, that the $2.9 million willful FBAR penalty assessed against Mr. Rund is not excessive.
May I ask you just a quick question so I understand your argument? You were challenging the aggregate amount of the fine, is that right?
Among other things, yes. We're also challenging the fact that the court decided that there was no genuine issue as to material fact with respect to willfulness.
Oh, I'm sorry. As to your excessiveness argument, your claim is that the aggregate amount of $2.9 million is excessive?
Under the Eighth Amendment
Okay.
gross disproportionality analysis.
Okay.
And then finally, that there was no genuine dispute as to material fact, which raised an issue as to which a reasonable jury could find for Mr. Rund. And we think that the best demonstration of the problem with the court's opinion is the manner in which the penalty was assessed and calculated. The total penalty is $2,915,663. What the IRS does is, for the relevant period, in this case there were 8 years, they look at all the years and then they find the year with the highest account balances. In this case, it was 2014, and there were 5 accounts in 2014. 3 of those accounts were HSBC accounts. And the balances in those accounts, the aggregate balances, were $2,516,586. 2 remaining accounts were China Construction Bank, CCB, and the balances were $3,314,000. They added those aggregate amounts, and the total was $5,831,325. Took 50% of that, came up with the penalty. Now, the problem that we have with that is for the HSBC accounts for 2014, for 2013, Mr. Rund reported each one of those accounts, same account holders, same account numbers, essentially the same amounts on a timely filed FBAR. It was $2.2 million. So essentially, Mr. Rund is being penalized 50% in the subsequent year for a delay in reporting what he had already fully reported the year before. And we feel that under the upholding in Bajikasian, when you look at the conduct, and what's the conduct here? The wrongful conduct here is a delay in reporting to the government information they already had. What's the harm? The harm is a delay.
Sorry, I thought Judge Harris had asked you, is your excessiveness argument the total number? But now you said yes, but now are you making an excessiveness argument just about the HSBC account? It's per account?
It is per account, but it's the total number, because the total number, the 2.9 million, is derived from the 3 HSBC accounts and the 2 CCB accounts.
I thought, but then the government takes that and they took that total number and then allocated it among all the violations, right? And it
They-
ended up being about like almost 14% of each account in violation per year.
That's correct. In other words, they'll take the high balance, and then when they take 50% of that, they'll allocate that among all of the periods and all of the accounts for which they allege that there's willful conduct. And it's allocated on a pro rata basis over those periods.
Well, let me make sure what test we're engaging in. Do you agree with the 4 factors that the government proposed for proportionality in this case? Do you agree with the 4 factors that they propose in the proportionality
Well,
test?
Your Honor, I think proportionality is going to be governed by Bajikasian, the Bajikasian factors. So I think we'd look at conduct, we'd look at harm, we would look at the target, what's targeted by the statute, and what the maximum penalty would be.
Well, now, that's a little different. What they proposed was the amount of the penalty authorized by Congress, the class of persons that the statute at issue principally targets, the harm resulting from the misconduct, and the comparison with potential criminal penalties. You agree with that test?
I think that the way I stated it was just another way of saying it. I do agree with that.
Okay, all right.
Yes, yes. So, again, in this case, the way the total penalty is calculated includes that HSBC, and we think that clearly runs afoul of the Supreme Court's holding in Bajikasian.
I mean, I guess I'm not, the emphasis on the way the penalty was calculated, I'm just a little bit confused. So
Sure.
the statutory maximum would have been just 50% of every account, right?
Well, it's 100,000, the greater of 100,000.
Yes, I'm sorry, yes,
No,
yeah, yeah.
yes.
But instead, the IRS has, takes a much lesser amount, which they calculate in this kind of complicated way. But given that you're coming in well under the statutory maximum, I'm just not really understanding why it matters precisely how it was calculated. I
Well,
mean, I take it the IRS policy is sort of a way of saying, we're not taking everything we could take here. Here's how we're going to do it instead.
So let's take a look at what the government contends here. And what they're saying is that if they had really just gone purely by the statute, the penalty would have been 9.8 million or whatever it was.
Do you dispute that? I mean, I didn't think that was disputed.
I think, yes, if you had added
Okay.
it up, that's what it would have come to, but that's more than double the amount that was ever in any of these accounts. In other words, the most that was in these accounts was $5,831,000. That would clearly violate the Eighth Amendment. So they're not doing Mr. Rund any favors by allocating in this fashion. They're doing themselves favors. They're avoiding or trying to avoid.
Well, I mean,
the
there's
Eighth
a
Amendment
pretty
argument.
strong presumption that when Congress sets a penalty, it's not unconstitutional, and so that any penalty within that range is sort of presumptively constitutional.
Well, I asked, Your Honor, would it be,
Well,
I mean, certainly Congress is going to be restrained by the Bill of Rights, and
Yeah,
certainly.
I'm just saying, do you disagree that there's a presumption that when Congress sets penalties, they're constitutional?
There is that presumption. And I think that this is a case which demonstrates that, that presumption is rebuttable, and I think the evidence in this case tends to demonstrate that. I mean, Bajikasian is, when you look at Bajikasian, the amount of the forfeiture was $357,000, and it was very clear, the court looked at that, and what was the opinion? The opinion was the only loss to the government was loss of information. And in this case, it's not even loss of information. The information had previously been fully reported for the HSBC accounts in 2013, so it was a delay in reporting what had already been reported.
So we have our Ahmad case, and we say that what was really going on for the Supreme Court is that was like a one-time violation. The guy only did it one time. And that's what made the penalty there excessive. But in Ahmad, we say, look, this guy, he's doing it like over and over again over a course of years. It's a sophisticated series of events, and that's what the difference is. How do you feel I mean, what's your response to our Ahmad case?
Well, I think that what's different about the FBAR, particularly if we're talking about a willful FBAR as contrasted with a non-willful FBAR, is that it has to be on an account-by-account basis. And if you look at the non-willful FBAR, the Supreme Court's ruled in Bittner that the penalty is limited to $10,000 per year, whereas here we're looking at it on an account-by-account basis. And I think that's the important distinction here, Your Honor. I agree with you, though. That does raise that issue.
So the gist of your argument is the manner of calculation, but as to your intent to conceal, and we define willful this way.
If I may, Your
Yeah.
Honor, and I'm
Yeah.
glad you asked that, because when we're looking just at this period, 2014, we have a lack of motive. Now, you know, I know that the Williams Court, which was decided by the Fourth Circuit, says that lack of motive was improperly used by the district court in the Williams case, because although they knew about the existence of account, they didn't know anything about control, extent of control, amount of funds, etc. This case is distinguishable, and I submit that lack of motive here, Mr. Runn had absolutely no motive for concealing the HSBC accounts in 14, and that would tend to negate any intent to conceal. An intent to conceal is a requirement.
Well, and my point is that the test for willfulness that we follow is, one, it clearly ought to have, the client clearly ought to have known, and two, there was a grave risk that an accurate FBAR was not being filed, and he was easily in a position to find it out. Now, did the court below follow that test? Chris?
Well, I don't think so, Your Honor.
You don't think so?
I do not, because I think that establishing any of these propositions, you have to have evidence. So, for example, in the Williams case, what did the court look at? Williams, during his guilty plea allocution, admitted that he had hid the $7 million in this foreign account from his accountant and from the IRS because he didn't want to pay tax on it. In the Horowitz case, they admit, and they came back to the United States, and they had no reason for these foreign accounts, but they kept them. In contrast, Mr. Runn, there were businesses. These were in corporate names. I see my time has expired. If I could...
You can finish your thought, certainly.
Yeah.
And then you...
There's a huge distinction. When Mr. Runn was asked about interactions with accountants, he was asked about what he told his accountant in 2003. Mr. Runn is 74 years old. He's being asked to recall a conversation that occurred 20-plus years ago. His answer was he couldn't remember, but he thought that everybody knew everything. The idea being he never, and there's no evidence that he ever hid anything from his accountants.
I know you're past your time, but I want to ask a question about that. Did he ever testify that he always did what his accountants and financial advisors told him to do? I looked, my clerk looked, we couldn't find that testimony, and that's the sort of testimony I would expect if you, I can't remember an exact conversation because it was so long ago, but I know I always did what my accountant advised me to do. Is there testimony to that effect?
Well, in his affidavit, there's testimony to that effect, that he followed the advice of his accountants. There is, yes.
In all instances, or just in particular ones that he identifies in the
I
affidavit?
believe it's in all instances.
Maybe,
Yes, Your
can you maybe identify that for me, and when you stand up again?
Yes.
That'd be helpful.
Yes.
Thank you.
Great, thank you.
Thank you.
Thank you, Judge Harris, and may it please the court, Sam Gedge for the amicus. I'd like to pick up on one of your questions, Judge Harris, the idea that if a penalty is within the statutory maximum, there is a presumption of constitutionality. The government, I think, echoes this in their brief by invoking the idea of deference to Congress's judgment in this regard. And I think that might be a little bit misdirected in this kind of case in particular, because in the context of fines or forfeitures that are mandated by statute, in Bajikajian, for example, the courts had no discretion. They have to issue the forfeiture. There, I think judges have an ongoing debate about the degree of deference or the presumption of constitutionality that should attach in the context of specific mandatory statutory fines and forfeitures. If you look at Judge Newsom's concurrence from the 11th Circuit, for example, I think there's a good discussion of some of those considerations. I think the calculus, though, is fundamentally different in a case like this one, though, because Congress did not pass a statute saying Richard Rund needs to be penalized $2.9 million. Rather, Congress passed a statute saying we are setting a statutory maximum with the theoretical worst-case offender in mind, and we are leaving it to the executive branch to determine in any particular case what the penalty should be. And in that context, I think a lot of the arguments about presumption of constitutionality, a lot of the arguments from the government about deference to Congress really fall away because particularly, I think, in the wake of cases like Loper-Bright, it doesn't make a ton of sense, I think, to talk about deferring to the Treasury Department when they're calculating a penalty that just happens to be within Congress's statutory maximum. Basically, under Loper-Bright and those kinds of principles, it just doesn't make a lot of sense to be kind of transporting those senses of congressional deference over to a decision that's ultimately resting in the discretion of the executive branch.
Let me ask you, should criminal forfeiture cases that allege excessive fines use the same proportionality test as in civil cases?
So we have taken the position that the gross disproportionality standard is the same. There may be kind of differences at the margins. For example, if, for example, the property owner in a forfeiture case is an innocent owner, there might be considerations about culpability that are less present when the penalty is obviously targeting the wrongdoer.
So you answer that question, yes?
Yes, with some caveats maybe for specific cases.
All right, then I'm trying to get you on the factors too. Do you agree we have clearly established those 4 factors? I think that you identified your brief. Do you agree with that?
So I don't know that I do entirely, Judge Floyd.
why not?
So as I understand it, this court has only articulated kind of 4 enumerated factors in an unpublished decision. Cases like Ahmed or Jalaram talk about it in more of a totality of the circumstances context. And I would, I think, quibble with some of those 4 factors. For example, the focus on the statutory criminal maximum. I don't think that does a whole lot of work in evaluating the culpability of a specific offender. And going back to my colloquy with Judge Harris, the statutory maximum tells us a lot about what Congress thought the maximum penalty should be for the theoretical worst case offender. It doesn't tell us a lot, though, about the specific culpability, the level of wrongdoing of the particular defendant in front of you. And the fundamental teaching, I think, of Bajikajian is that that is the real question when we're evaluating the gravity of a particular defendant's offense.
Well, if
Yes,
that
sir.
be the case, I mean, you quibble with them, how are we going to evaluate your actions?
Yeah, so I think kind of the through line error in the district court's excessiveness analysis was not so much how it handled any one of those specific factors, though again, I would kind of take issue with some of those factors. I think the broader error, though, was that at almost every turn, the district court was evaluating Mr. Rund's culpability at a really stratospheric level of abstraction, rather than doing what the Supreme Court did in Bajikajian and looking to Mr. Bajikajian's specific wrongdoing, the degree of harm that he himself caused, where he fell on a relatively broad spectrum of culpability. I think that, in fact, kind of has a special force here, where at least in Bajikajian, because we're talking about a criminal reporting violation, there was a narrower level of mens rea that might trigger the statute. Here, by contrast, to your point earlier, Judge Floyd, civil willfulness under the Bank Secrecy Act is substantially broader than criminal willfulness.
But those factors I asked you about a while ago come from, how'd you say it?
Bajikajian, yes,
Yeah,
sir.
that's where they come from.
Well, the courts have interpreted Bajikajian to kind of distill factors like that, but I think the fundamental teaching from Bajikajian, which we emphasize in our brief, and I'll emphasize here too, is that basically your task is to review the totality of the circumstances and focus not on the gravity of the offense at kind of a pretty high level of abstraction, but rather to focus in on the specific culpability of the offender. Are they on the kind of pure heart, empty head end of the spectrum, or are they on the deliberate, knowing violator end of the spectrum? I think there's a question of material fact on that here. You ask, what are the actual harms to the public fisc from this particular violation, not writ large, what are the harms that can follow from Bank Secrecy Act violations as a whole? And I think those kinds of, that level of generality issue, I think, is what gives us a lot of concern with the district court's excessiveness analysis here. And really, however the facts cash out in this case, we would urge the court not to replicate that kind of really high level of generality in evaluating excessiveness. I do, if I may, also want to touch briefly on the order of operations question, because I think there are compelling reasons in the Eighth Amendment analysis to decide the first order question first, namely, does the excessive fines clause apply here at all? And there are a couple of reasons for that. The government, of course, suggests that the court can bypass that question, assume without deciding that the clause applies here, and then affirm on excessiveness grounds. I think there are a lot of landmines to doing that on the excessiveness front. But also prolonging uncertainty on the threshold question, I think, is uniquely disruptive here. Could I finish my thought really quickly, Judge Harris?
You can more than finish your thought, because I have some questions.
Okay, well, I'm happy to answer them.
You can finish your thought first?
Sure. So to my point that leaving that threshold question unresolved, I think is uniquely disruptive, follows from the fact, to my point earlier, that unlike with lots of other kinds of civil penalty regimes, unlike criminal fine regimes, the power to actually determine any specific FBAR penalty rests not in an Article III court, but with an executive branch agency. And that agency firmly believes nationwide that the excessive fines clause places no constraint at all on how it goes about settling penalties in any particular case. So for that reason, I think there's an urgent need here to bring clarity to the question whether the clause applies here at all, not just to bring guidance to the lower federal courts, but also to give guidance to the executive branch agencies that in the first instance are the ones deciding, should we be imposing a $9 million penalty or a $2 million penalty? Because right now, they're imposing those fines on lots of people who never actually see the inside of a courtroom, and they're doing it on the assumption that the Eighth Amendment has nothing to say about how they exercise their discretion. And I'm happy to answer your questions,
So
Your
on
Honor.
that question of is it a fine at all, I mean, I take it that your position, if we accept your reading of Austin, right, any penalty that goes beyond remediation has any deterrent effect, that's a penalty. That does mean that all civil penalties are fines now, right?
Most of
And
them are, yes, Your Honor.
The court
And-
said that in Hudson, right? Like, look, there's, every penalty has some deterrent effect.
Yeah, I think that's right. And
Okay.
you might be able to kind of conceive of some kinds of things that are maybe misnamed penalties, but that actually are purely compensatory. We can envision some kind of maybe restitution scheme where it really is a dollar for dollar situation that might fall into that that conception of remedial. But yes, I think the short answer is yes. When we're talking, like, it's called a penalty for a reason. It
Yeah.
penalizes people. It's
Right,
punishment.
That's what Justice Gorsuch said, right.
yeah.
And so every fine, every civil penalty is a fine, and in order to avoid an excessiveness problem, every imposition of a civil penalty will be accompanied by something like a sentencing hearing, a criminal sentencing hearing into individual culpability, all of the circumstances.
So not necessarily, Judge Harris, in that at least in this circuit, the excessive fines clause has been interpreted as an affirmative defense. So the defendant in a civil penalty action would have to raise it.
Okay,
and
so let's say the defendant raises it.
Sure, and it would, again, under this circuit's precedent, it would be their burden to kind of establish that there's an excessive fine here. But yes, and I think realistically, if we're talking about a parking fine, for example, yes, it probably qualifies as a fine. I think there's no world in which, a court's going to say that's
Yeah.
excessive.
Right, but like your regular agency civil penalties will pretty much be a thing of the past. It will just be wholly unworkable, which, it can totally be like a feature and not a bug, but it makes me a little bit nervous as a lower court judge that we would issue an opinion that says, fundamentally, every civil penalty is a fine, and under the excessive fines clause, we're going to have to give every person or company upon which one is imposed something like a criminal sentencing.
I think that's right, with the caveat that, like, in the FBAR context, for example, lots of these FBAR cases don't make it into an Article III courtroom to begin with. They drag on for 10 years, the person runs out of money, they can't pay for a lawyer, they just pay up. So I think a lot of these cases don't actually see a judge in the first
I guess
place.
I'm thinking more of companies almost than individuals. I feel like a lot of these penalties are being imposed against companies, and, they will definitely pay up, and it will become more or less unworkable, I would think.
Well, I would disagree that it would be
Okay.
unworkable, Judge Harris, because I think where the excessive fines clause is going to be doing the most work in those hypothetical situations is where you have the federal government or state agencies imposing exorbitant multi-million-dollar penalties. And there's already going to be a lot of process, right? Like, companies fight when they're trying to get hit with multi-million-dollar penalties. So I think just at the margins, yes, there will be another issue potentially that they can raise, but these are cases that often drag on in the courts regardless. And I do also kind of want to also make the point that I think the excessive fines clause often has its most urgent application, not when it comes to companies that are getting hit with multi-million-dollar fines and it's a drop in the bucket for them. Like, yes, there are those cases. The excessive fines clause has important application.
Yeah, I'm not, actually, it's just weird because of my particular experience. I'm not even thinking of those companies. I'm thinking of the smallish companies that will argue, well, I'm thinking of the smaller kind of fly-by-night companies.
Sure, and I mean, I think, I'm not here to defend fly-by-night companies, but, I mean, I think my reaction to that is, like, yes, we actually want courts to be involved when governments are imposing exorbitant
Like
penalties.
I said, it's a feature, not a bug.
Right,
Yeah.
right, and it really only does come into play when folks actually take advantage of this affirmative defense and, carry the burden that this circuit has said they have to carry. So I'm certainly happy to answer any questions the court may have. All right, thank you very much.
Good morning, Your Honors. My name is Nishant Kumar. I represent the government. So, touching really quickly on the willfulness question that is technically on appeal here, Richard Rund committed a few dozen FBAR violations after he knew what the FBAR was and after he'd already submitted an FBAR for an earlier year. So that makes this case stronger, simpler, more straightforward than Horowitz or a lot of the other recklessness cases that the SDNY collected in its Gentges, G-E-N-T-G-E-S opinion that we cited in the briefs, because here you have someone who knows about the FBAR and still failed to pursue information about what he had to put on it. And in Horowitz, for instance, you had courts finding the Horowitzes reckless even after crediting them with genuine ignorance of the FBAR itself. I wanted to address your questions, Judge Rushing, about the possible question of material fact that is kind of bouncing around here. Here's how we see it. No reasonable juror could find, based on the evidence, that Mr. Rund told his tax preparers about all these accounts back in a timely manner and was advised time and again not to report them, which is kind of the story that he's saying lurks in like the realm of possibility, because unlike the Horowitzes, he hasn't conclusively said on the record, I never told my tax preparers about these accounts. He's only said, I don't remember, and there's that statement, everybody knew about everything. But if you could take the evidence that he never told them is that, of course, they were not reported. Back when he came before the voluntary disclosure program in 2010, and he wrote a letter explaining his earlier omissions. Nowhere in that letter is it, I actually told my preparers about these accounts and was given the wrong advice. And so you have evidence like that, all of which cuts one way, that he never told his preparers. And then you have the statement, everybody knew about everything, as the only counterweight. If for a defendant to say everybody knew about everything was kind of a get out of summary judgment free and get to the trial, because that itself creates a reasonable dispute, well, we're just saying it shouldn't be that. It cannot be that. And so we don't think there's a genuine dispute here that he failed to mention these foreign accounts to any of his preparers in a timely way.
What is or do you know the status of the case in the tax court, and if so, is there a final figure?
I do not know the status of it. It is not a final case, so I have no idea what the final figure is.
Well, the district court said, I think that this particular person caused a significant loss in tax revenues. where is, I mean, what is the best information in this record about the amount of the lost tax revenues here?
So the best information, so if we're I think the court made that observation and maybe said it can't be said that succinctly. Maybe we think, rephrasing that is, it's Mr. Runn's burden under the excessiveness factors, which is where this came up, to show that his non-reporting does not correlate to any tax loss. And he certainly cannot meet that burden right now because there has not been a conclusive determination. There was no tax loss. There's a pending tax case where, you know, the government, at least at the beginning, asserted millions of dollars in tax loss. So if...
Can I just, because
Sure.
I'm not a money person, I don't really understand this, but is the idea that if he didn't disclose the accounts, he couldn't have been paying taxes on the interest earned by the accounts? So like the starting presumption is there were some taxes here that weren't paid, and if that's not the case, the burden is on him to explain why not disclosing the accounts didn't cause a loss?
There's more than that in
Okay,
this
what else is
case.
there?
That would be if there were not a tax court case even so we would have to rely on that very like bare bones presumption were there not a parallel tax court proceeding in which people assigned to determine his tax liability found actually, as far as they know, that there was a lot of unreported interest, a lot of unreported account. Yeah, the income tax, you're correct, Your Honor, would be what would be owed on interest that's accruing on the funds that are in all these multi-million-dollar foreign accounts.
Okay, the funds themselves, taxes have been paid on the funds. The question is the interest? Is that?
Sometimes taxes have been paid on the funds. For instance, if you are, in the Horowitz's case, they only put post-US taxes into the Swiss account in question, and then it grew tax-free. But here, for instance, you had the UBS account where there also isn't, Mr. Run thereby managed to evade taxes at the front end as well, because what it was a company, the UBS account got $25,000 a month from the companies that Run controlled in Hong Kong, so that the Hong Kong companies reported less income per year. So they paid less taxes in Hong Kong, moved money to this account in Switzerland, held by a company, you know, with a puppet board of directors that acted at Mr. Run's orders. So basically, there he had money that hadn't yet really been taxed in Hong Kong where it was earned, or in the U.S., though he could kind of control that, you know, it was a kiddie for him. Unless there are other questions about Mr. Run's ADHD defense on willfulness, I was going to move to the Eighth Amendment arguments, Your Honors. Okay, so as we proposed in the briefing, we think the doctrine of constitutional avoidance and not answering a constitutional question unless it becomes necessary should guide this court to kind of assuming but not deciding that civil FBAR penalties are fines, because it's just not a close question on excessiveness. And that is a path well trod. The Ninth Circuit in Bustle did that, assume but not decide, and then this isn't excessive. Bustle was regarding the civil FBAR penalties. Then in regards to other exactions that were challenged under the Eighth Amendment, the DC Circuit in Bikundi, the Seventh Circuit in Grasshoff, have both of which are cited, have taken the approach of let's assume but not decide the fines, the threshold question, move on to excessiveness, because excessiveness is clean cut. Here, as Your Honor mentioned, there's a strong presumption of constitutionality because the penalty amounts are like a third of the statutory maximum.
Where does that come from? Where do I get that principle that we presume that it's constitutional because Congress enacted it?
Sure. So Bajikajian sets out a general principle out of like deference to Congress is the foremost at the forefront of setting remedies for social wrongs. We're going to there's a presumption of constitutionality. Bajikajian.
And I thought Bajikajian says, because of that we, there's a measure of deference to Congress. We presume that they're acting constitutionally. We're going to want to be careful in these, that because of that, therefore, we are setting the standard for excessiveness at gross disproportionality, right? Like the court wrapped all of that into the standard, and then we apply the gross proportionality standard. But when we do that, we don't add an extra layer of, is this grossly proportional? We're going to defer to Congress on that, right? Like you're kind of adding deference in again.
Yes, so understood, Your Honor. So the court, the Fourth Circuit case I would point the court to is U.S. versus $134,750 in U.S. currency, and it's 535 Fed Appendix 232 in this court, where they talk about the strong presumption of constitutionality as if it's the first factor.
But that Fed appendix means that doesn't bind me.
Correct.
Right, okay. So that might have been wrong, and I don't have to follow it.
So, yes, Your Honor, and I will say it's unclear what extra work. I had the same question. If the baseline requirement for the person challenging the penalty is they have the burden of showing gross disproportionality, like what else does it add to the scale to say also when the government's fine is below the statutory maximum that there's a strong presumption of constitutionality? Is that just saying the same thing in two different ways? It is unclear. We are happy to rely simply on the gross disproportionality requirement and not add some oomph of strong constitutional presumption. But one thing I think that's where we would be happy to leave it. We think so we don't, having said that, if we move through the Bajikajian factors, the other factors, and apply, keep in mind that it's runs burden, you have the question of whether he is among those targeted by the penalty provision at issue. And on this, I just wanted to make one, there's a kind of a potential for error here because of some lack of clarity in Bajikajian. In Bajikajian, the court found that Mr. Bajikajian was not among those targeted by the statute that was at it, the penalizing statute, because the penalty statute was not the Bank Secrecy Act. It was this corollary crim forfeiture, 18 U.S.C. 982. And so the court made that comment that forfeiture act, the section 982, is targeted at drug traffickers and criminals and blah, 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 and not people like Bajikajian who made just this reporting violation. Here, we're not penalizing him under some far-flung forfeiture statute. The BSA, the same statute that is defining his misconduct, is the one setting out the penalty that we're relying on. So
in this case, Mr. Rudd is not suspected of money laundering or drug trafficking or anything, is he?
no, he is not. No, he is not. I merely meant to say that observation is that doesn't mean he's not targeted by the BSA. The language in Bajikajian saying Mr. Bajikajian is not the target of a statute directed at drug traffickers, money launderers, is fine, but it's not apposite here, because the BSA is targeted at people like Mr. Rund, who it's defined the prescribed conduct and defined the penalty for that prescribed conduct. And the 11th Circuit in Schwartzbaum, too, which obviously we don't agree with all parts of it, or their decision on the fine question, but on excessiveness, they point this out at page 281 of their decision. I think they kind of talk about how Schwartzbaum is targeted by the BSA, unlike Bajikajian, who was not targeted by that forfeiture statute.
But Mr. Rudd, he's just kind of an off and on reporter. Would that be a fair characterization? He reports, and then he goes a while, and then he misses, and then he reports.
That is an accurate summary of one strand of his non-reporting. That's his HSBC account, which is one small part of his non-reporting, where he kind of winks in and out. Some years he reports it, then the next year he doesn't, then the next year he does, next year doesn't. There's other accounts where he never reported them until he eventually did the voluntary disclosure. So the UBS account held in the name of FEV, I forget what it stands for. It's not that he didn't report it. It's that he didn't report, from the time it was opened in 03 until he filed late FBARs in 2010 for a bunch of years going back.
But you contend that his conduct is willful.
Yes, we think his conduct is cleanly willful, just as you compare it to Horowitz. His conduct is willful because he was at least as reckless as the Horowitzes. And also, just to make a point, a lot of Mr. Rund's brief appeared to attack this, point out how certain facets of his conduct were plainly inconsistent with an intent to conceal. That may be true, but we're not, the basis of our case isn't that he had an intent to conceal. Their statements would carry weight if this was a case of knowing concealment. It is a case of recklessness, so it really doesn't speak one way or the other to whether he was reckless. Turning back to the Eighth Amendment and the Bajikajian factors, and going through them with Mr. Rund's burden in mind, the other factor, we then turn to the harm caused by Mr. Rund. And here we think we have to discuss a little bit the discovery below, but we think basically the absolute nullity of evidence on this question cuts against Rund, because it's his burden to show
I wondered about that, because the harm, it seems like really only the IRS knows the harm that they're claiming he caused, right? In terms of both tax dollars and I think you mentioned in your briefs harm in the way of investigation and having to track down this sort of misbehavior. How is he supposed to prove that? And do we have enough in front of us to decide that, or is it something we'd need to send back to the district court?
So we don't think you have to send it back to the district court, because we think the absence of information, which I'll explain why that kind of rests with him, cuts dispositively against him. The fact that he doesn't have this information is because it would be different if Your Honors ruled, well, this gets into the practicalities. In the district court, Mr. Rund's discovery said, what does the government contend is the dollar amount of damages it sustained from Mr. Rund's FBAR omissions? We said We do not make a contention one way or the other on that. We're not contending no damages. We're not contending damages. We are essentially refusing to answer this.
So
on-
how is he supposed to find out?
On grounds of relevance.
Right, if he has the burden, how
He
does he
should have
find
moved,
out?
so in that case, if he really thought, this should have been teed up below in the context of he should have moved to compel, as the district court in footnote 19 said, if you think this is relevant, as we move to compel, again, you move to compel, and then you'll get your answer. And then if the court had ruled, the district court had ruled against him, if he had raised a discovery dispute, and the district court had said, no, it's not relevant, you know, you don't, and therefore he never got this information, that would be an order that would be folded up into this appeal that Mr. Rund could have challenged, but he simply never pressed for this information.
The district court kind of treated it as irrelevant. I don't remember its excessiveness analysis getting into, you know, the dollars of, the court kind of assumed, like, the tax case is still going on, like that, maybe that will resolve and tell us the damage the government claims.
So we would say, regardless of how the district court couched it, I think it did correctly say it, like, I think it was footnote 9, page 19 of its order, how the government was, there is no evidence one way or the other. We'll presume a tax loss, like the district court said, but there's actually no concrete evidence one way or the other on the amount of societal harm that Mr. Rund's violation caused. I'm out of time. May I finish my sentence?
That would be great.
That any, the fact that no one in this case has a dollar amount, you know, to correspond to Mr. Rund's FBAR violation is really rests on his shoulders and defeats his excessiveness showing. If I may, we never addressed the threshold fine question, but when we're talking about, I would just ask this court, when it's considering Justice Gorsuch's, you know, comment that non-punitive penalties are a contradiction in terms, the Supreme Court historically has very much not seen it that way with the customs forfeiture cases, the Halper itself talking about double damages plus a fixed fee can be said to do no more than make the government whole. So we think, as much as it may surprise the man on the street, under the jurisprudence, this civil penalty is nothing more, is no less purely compensatory. The realm of what is purely compensatory is very, very expansive under the Supreme Court's jurisprudence, and this falls within that very expansive realm. Thank you, Your Honors. If there are no further questions. Thank you.
I'm going to cut you off before you even start, because there was one question I did want to ask about the kind of threshold question of, is this a fine or not? As I read our decision in Thomas on the income tax penalty, we said that we weren't going to apply the Austin standard, a penalty is a fine unless it's purely remedial, that we wouldn't apply that outside the forfeiture context. And that was a long time ago. It was in 1995. But what Supreme Court case would you point to as having kind of superseded that precedent so that we don't have to follow it?
Well, I would think, and give me 1 minute here, Your Honor, the Bajikazian case.
But that was a forfeiture case.
It was a forfeiture case.
Okay.
And I think that
Because, you know, our rule on our precedent is that if there's any way at all we can reconcile it with what the Supreme Court is saying, we need to follow our precedent.
okay. Well, I think that the that case involves tax fraud. And the tax fraud is going to be connected to, in other words, if there's a $1 million deficiency that results from tax fraud, and if we're at the 50 or 75%, whatever, that's going to follow along, so that's going to be clearly connected with the damages there. Whereas in this case, as the court points out, if you have $1 million that is not attributable to any malfeasance other than this reporting, failure to provide the information, your penalty is going to be $500,000. If it's $2 million, same facts, only more, no connection to anything that the owner of the account is doing wrong. It's kind of
So there
disproportionate.
might be ways to distinguish it. Let me just, I asked your able amicus, bottom line is the position that every civil penalty is a fine. And he thought, yes, more or less. Do you share that view?
I do.
Yeah.
Yes. And I see my time.
Oh,
Has
I
expired.
cut you off.
No.
Feel free, take a minute or so.
Your Honor, I think that we've made our position clear. Unless there are any other questions.
Great. Thank you very much for your time.
Thank you, Your Honor.
If you wouldn't mind, we would love it
Yes.
if you would come up and greet, so that we can greet you, and then we will hear our last case.
You know what I mean, when you say we affirm reverse enforcement. Well, just write it out. You can, just take it back out there. Here. They have a hard time checking in. Thank you.
All right, we will hear argument now in our last case of the day, number 24-2081, Winnebago Tribe of Nebraska versus United States of the Army. And Ms. Wright, when you're ready.
May it please the court, my name is Beth Wright and I represent appellant the Winnebago Tribe of Nebraska. Here with me in the courtroom today are current and former Winnebago tribal leaders. The district court should be reversed. NAGPRA's purpose is to provide Indian tribes with a statutory right to bring home the remains of their own citizens from places they do not belong. NAGPRA provides Indian tribes additional rights to ensure repatriation is tailored to the unique needs of Indian tribes.
Counsel, I'm sorry to interrupt, but before you get to the merits of your argument, can you just explain to me sort of why we are here? I'm looking at this letter from the Army from December 23, offering to return the remains of Samuel and Edward at the Army's expense in a dignified and respectful manner. There are a bunch of details. So why is there still a justiciable case or controversy in front of us? It seems like the only question is sort of which authority will be used to effectuate this return.
Yes, Your Honor. A few points to that. NAGPRA itself gives any person a cause of action for any violation of this chapter. So Winnebago has a right as a sovereign nation under NAGPRA to bring home the remains of its citizens, and the Army has not said it will return the remains to the tribe itself. It will only return the remains upon the identification of a closest living relative.
Oh, I thought we were already past that, I thought I read in the briefs that, they'd kind of they had taken a very liberal reading of this regulation and were prepared to do it in this case. I mean, you think but you're saying all of this is actually contingent on a condition that can't be satisfied in this case?
Yes, Your Honor. Under the Army's process requires 2 affidavits.
No, I know what the Army's process looks like on writing, but I thought this letter was saying this will happen. But you were saying, no, this is just a letter saying, if you satisfy this other condition, we will do this.
Yes, Your Honor. And as Winnebago pled in its complaint, it attempted to identify the closest living relative, but because of the circumstances surrounding Samuel and Edward's death, it was unable to determine who that person was. Samuel and Edward died as children without any lineal descendants of their own, and now asking the tribe to identify who that person is a challenging task. And NAGPRA not only provides tribes a right to request repatriation and facilitate repatriation as a sovereign nation, it provides tribes additional rights that don't appear anywhere in the Army's process. Some of those rights include mandatory repatriation under the Army's process. Return of remains is just discretionary. Some of the additional rights.
Right. But those, it seems to me, once the Army says, but we are using our exercise to return the remains to you, it really wouldn't present a justiciable controversy. But you're saying the Army is not saying that. They have not told you they will return these remains.
Yes, Your Honor. Just briefly, the district court erred in dismissing Winnebago's action because it distorted NAGPRA's plain text and because it violated the standard of review by failing to accept the truth of Winnebago's facts. I have 3 main points. First is that the district court's ruling creates a holding or collection barrier to repatriation that has no basis in NAGPRA's plain text. Second, Samuel and Edward's remains are part of a holding and collection. And third, the district court misapplied Thorpe v. Borough of Thorpe.
Well, let me ask you, in terms of the breadth of the statute, if this statute is interpreted without the holdings and collections requirement, won't that make Native American remains within federal control subject to disinterment?
Not necessarily, Your Honor. If there is no holdings or collections requirement, which is our first theory, that under 3005A4, a tribe doesn't have to show that there is a holdings or collections in order to be entitled to repatriation, a tribe still has to prove cultural affiliation with a specific set of remains and identify a specific set of remains that's in the government's possession or control in order to be entitled to repatriation of those.
And so secondly, does the line such Native American human remains in the statute refer to those that were eligible to be in inventories or summaries?
No, Your Honor. The specific language in 3005A4, which I think you're talking about, is not included upon any such inventories. The text ends there. There's no other language in the statute that says they're not included upon inventories, but they're still subject to the inventory provision.
So let me give you this scenario. Obviously, this cemetery is adjacent to the War College, and it has signs about people being able to tour and view the graves and that sort of thing. There may be another qualifying fact that I can't recall right now. Would that scenario not at least make the remains qualify under the holdings definition, if not the collections definition for disinterment?
No, Your Honor, not the mere availability of a tour makes remains a holding and collection.
Does make it.
not the sole availability that you can tour a site and see the graves. That's not the only fact that makes remains a holding or collection. What makes these remains a holding or collection is that they were buried at Carlisle without consent of the tribe or the families, and then the government dug them up in 1927 and moved them to their current location, again without consent of the tribe or the families. And after that, the government has since treated these remains consistent with the ordinary definition of holding or collection. Some of those facts include that the government does use the remains as part of the walking tour, but other facts include that the government has studied these remains through ground-penetrating radar surveys and research reports, that the government has called Carlisle Cemetery specifically a repository for the remains
So
of...
these human remains are in the grave, right? They are in a grave.
They're in the ground, yes, Your Honor.
What's your best argument from the statute that it creates any obligation regarding human remains that are still currently buried?
Well, Your Honor, the purpose of NAGPRA is to...
Well, like in the statute, though. So the statute seems to address two kind of groups of human remains and artifacts. One is human remains that are buried, and the statute, like in 3002, addresses, if they are accidentally discovered on federal land, what is your obligation? If they are excavated with permission, what is the obligation, right? It's all of the references to human remains that are buried is about unearthing them. If they are discovered, if they are excavated, here's who own, you don't own, but here's who controls, et cetera. And then the statute, in other provisions, the Act talks about human remains that have already been excavated, that are in holdings, in collections, or maybe are otherwise held by these entities not in holdings or collections. Neither of those groups seems to be talking about who controls or any obligation regarding human remains still in the grave. Is that a correct reading of the statute?
No, Your Honor. Under 3005, it mandates that when a federal agency or museum has illicit possession or control of Native American human remains, and upon a valid repatriation request, that the federal agency return those remains to the tribe or the requesting entity. There aren't...
But where's the, I guess I'm just troubled by the fact that when the statute is, when it's talking about buried remains and obligations regarding them, all of the language is, removal, excavation, these sorts of words, and none of that is in 3005. There would have to be an obligation to first dig up, to first disinter, and that not only is, I don't see that in the statute.
Well, under 3002, it doesn't say that you can never dig up Native American human remains. It does say that you can dig up human remains if you follow these certain procedural steps.
Right, but where's the obligation to do it?
Well, there is an obligation to seek a permit under ARPA, under the Archaeological Resource Protection Act.
Right, if anything, the statute seems to really want to limit that and say we are leaving the remains where they are unless, right, subsection C says unless it's only permitted if you can satisfy certain requirements. That seems to be communicating a purpose that this statute has nothing to do with human remains buried in a cemetery on federal land.
Well, under the Archaeological Resource Protection Act permit, a permit is not required if you are complying otherwise with federal law. So we didn't really brief the permit scenario necessarily, but it doesn't mean that you can never excavate Native American human remains only if you do these things under the options provided for obtaining a permit.
Right, but our question here is, does this statute create an obligation to disinter buried human remains, and where is that obligation in the statute?
There is no specific language that says the federal agency must disinter or must do something to return remains, but the fact that 3005 is a mandate on federal agencies to return Native American human remains contemplates that there would be scenarios where they would have to take on different measures to actually return the Native American human remains that they don't have consent to continue possessing.
Well, Ms. Wright, let me ask you this. Tell me how we can interpret the statute to put the remains back in the control of the tribe.
Just through 3005A4, Your Honor. Under 3005A4, remains not included upon any such inventory are these very scenarios of Samuel and Edward. Samuel and Edward were not listed on an inventory, so this broad language in the statute is contemplating scenarios where remains would not be listed on an inventory, remains would be intentionally left off an inventory, remains wouldn't be subject to the inventory provision.
But the
for whatever
inventory
reason.
provision only applies to holdings and collections, right?
Yes, Your Honor.
So if there's a cemetery on federal land, it's not covered by the inventory provision, right? I mean, that's
Well,
right.
because holding or collection isn't defined by the statute, you look to whether, based on the facts, is the government or entity treating these remains as a holding or collection. And so a holding or collection could potentially be a cemetery as it is here, because based on the facts, the government has treated this as a holding or collection by the fact that they moved these remains from their current burial spot to this location in order to build a parking lot, and because they have demonstrated their intent to treat Carlisle Cemetery not as an ordinary cemetery, but as a place that they've called, in their own words, a tribute to Native Americans, a historic site. And there's the facts in the complaint that discuss how the government would not return remains to tribes when they asked, because they wanted to maintain the character of the cemetery.
Does that
as
apply to like Arlington as a tribute to our service members? The tours are conducted, et cetera. Does the government need to inventory any tribal members buried in Arlington?
No, Your Honor. Carlisle is not like Arlington. Carlisle was established because the government dug up these remains without consent of the families and tribes and moved them to build a parking lot.
What's the statutory difference? Where do I find that difference in the statute?
In the ordinary definition of holding or collection, because based on these specific facts that we have here, that Carlisle is a holding or collection, but these facts do not mirror facts of comparable to Arlington.
So it's a holding or collection, but Arlington isn't, because why?
Because the government treats these remains at Carlisle Cemetery as a holding or collection.
Sorry, help me understand that. How do they treat them at Carlisle that way, but not at Arlington National Cemetery?
Because of the lack of consent, there was no expectation that Samuel and Edward would die at Carlisle and remain at Carlisle forever, that they would be moved.
So the definition of holding or collection involves lack of consent to be in said holding or collection?
Well, it's presuming that the government has acquired the remains somehow, or has collected or obtained the remains somehow and is using them in the character that makes them property or makes them something that the government or museum can study, or is using as for an exhibition. So it's based on those specific facts of holding and collection. And what's helpful is in Thorpe, the court talks about holding or collection, and it says that holding or collection means something that the government is holding or collecting for a purpose other than serving as an original burial site. And so at Carlisle, we have two different scenarios where Samuel and Edward's remains are not their original burial site and have never been their original burial site, because there is no lack of consent, there is the lack of consent from the tribe and the families. I see my time is up. Thank you.
Thank you. You have some time on rebuttal. And Ms. Roundtree, we'll hear from you.
Good morning, Your Honors, and may it please the Court. The threshold issue in this case requires that the Court interpret Section 3005A4 to determine the full scope of criteria for human remains that qualify for repatriation under that provision. Now, this Court has recognized that to determine the plain meaning of a statutory provision, the Court doesn't look just to the language of the provision itself. It also looks to the context of the language, where the language appears, and the broader context of the statute as a whole. Now, that principle is particularly important in this case for two reasons. First, one of NAGPRA's purposes is to provide for the protection of Native American graves, to protect them from disturbance and protect their contents from being disinterred.
I mean, but does that really apply here? It's not as though anyone, these were burials without consent. There was no Native American burial. These kids are kidnapped, dumped in a grave after they die at the government's hands, and then moved so that they can pave over the graves with a road. Do you think Congress's point was like, we really need to preserve that setup?
No, well, Congress, ultimately, this statute is to preserve graves. So notwithstanding how the burial might have occurred, it's so that
I don't
the
feel
graves,
like, well,
so
okay.
that the graves aren't disturbed. So, for example, someone just can't come along and say, I want to take these remains on the road and show them to everyone, so disinter them. It's to protect the graves so that if they are disinterred, it's for a reason that's consistent with the statute. So while the Congress also provides for the protection of the graves, it also provides for the repatriation of items of Native American items. But in keeping with that objective to protect graves, Congress allows for repatriation only under specific and limited circumstances. Now, there were three interrelated sections in NAGPRA that address those limited circumstances, and importantly, they do so sequentially. In sections 3003, 3004, and 3005, Congress sets forth a sequential process that certain museums and federal agencies must follow for the repatriation process to occur. Now, section 3005A4 at issue here is the last of the steps in that sequence. And what that means for purposes of statutory interpretation is that section 3005A4 does not exist in a vacuum. Rather, it builds upon and is substantively dependent on the preceding steps in the repatriation process, namely 3003 and 3004. So therefore, 3005A4's criteria for human remains, which is what the issue is about here, cannot be determined by looking at that provision in isolation. The criteria for human remains in 3005A4 must be interpreted building on the criteria for human remains that's already been defined in section 3003. So if we focus on just the two provisions that regard human remains, those are 3003 and 3005.
Well, maybe she misunderstood my question, but the district judge ruled that the remains at Carlisle Cemetery did not qualify as a holding or collection under the statute.
Mm-hmm.
That limitation really frustrates the intent of this statute under these circumstances, where there's no consent and there's a reburial.
Well, Your Honor, I appreciate your point, except the statute says nothing about, in terms of this repatriation and these three steps which govern repatriation, about consent. What it's talking about now, it has specific, for example, I was about to get to section 3003.
Well, before you do that, maybe you can address it. Had the district court found that this was a holding or collection, then their repatriation would be simple, would it not?
If the government found that these remains were in a holding or a collection,
And so my question is, insofar as a holding or collection, I mean, those are common words, and you can go to a dictionary and get a definition of a holding, and when it talks about some of the things that can happen is that for public benefit, like a tour and that kind of thing, the graves are out there for people to read about it and see the graves, and et cetera. Doesn't that get into a position where the tribe can repatriate those?
No, well, again, going back, we have to focus on the provisions that speak to repatriation, because that's what's being sought here. They've sought repatriation under
But I
NAP.
thought your whole position is, the way you are reading section 30054, it can only be repatriated if it's part of a holding or collection.
Yes.
And Judge Floyd is saying, great, why is this not part of a holding? So I don't see how going back to your textual statutory argument
Well, it's
addresses
just that
that.
3003 is where holding and collection, that describes the universe. In section 3003, it describes the statutory universe of remains that are subject to the repatriation process. That's where we begin. That's step one in the repatriation process. And in section 3003, that's where it says holdings or collections over which the federal government has possession or control.
Great.
That's our starting point.
Okay, I actually disagree with that, but that's where Judge Floyd wants to meet you. So why is this not within that provision as part of a holding?
Going to the dictionary and regulatory definition of holding or collection, it's the gathering or accumulation of objects for a specific purpose or
It doesn't-
reason. Yeah, those are the definitions. If you look at both the dictionary definition and the
The
regulatory.
regulation doesn't say specific purpose, it says
Well, I'm
any
sorry, for
purpose.
a
And I'd have
purpose.
to say, you made that mistake several times in
I
your brief,
apologize.
and I thought you were very close on the duty of candor. It does not say specific purpose, it
I
says the
apologize.
opposite. Okay.
Okay, well, before a purpose.
It says
or
any purpose.
any purpose or reason. Therefore, there must be a purpose or reason associated with the gathering and accumulation. And here, there's nothing alleged in the complaint that says that the government gathered or accumulated these remains for purposes that are in any way consistent with the definitions of.
So if tomorrow the government disinterred these remains and put them in a glass case, you would say they are not part of a collection or a holding because that's not why they were originally gathered or accumulated?
That's a separate issue. Anything that's interred after the passage of the statute,
Okay,
disinterred.
but
after
just,
the
it would
passage-
still not fall within the definition of a holding or collection, in your view, because that only applies if the original purpose was to,
Well, I'm just saying in this case, I'm starting first with the original purpose, and I'm not saying original is in a definition. I'm saying here, because we have remains, they're, I guess,
but they're now part of a historical tour. It's like an outside museum.
No, the remains which are at issue here are not displayed. There is no showing of the remains, there is no exhibition of the remains, there is no display of the remains, and the public is not given access to the remains. It's the cemetery, which is now located on the military barracks. So if individuals, if we go with the allegations in the complaint, if individuals are on the barracks, there is a cemetery in front of them. And the military has simply said a fact, which is, this is a cemetery which holds students who used to be enrolled in the Carlisle School. That doesn't speak to how gathering occurred, if there was gathering. It doesn't say that the government accumulated these remains for purposes of displaying them, because indeed they're
Does
not
that
even
go to
displayed.
the point that, I mean, how does one gather or accumulate human remains? You have to disinter them, right? The remains, I mean, this is a grave. This is a grave site that's not, the remains become accumulated or gathered by disinterring them, and then, then you have them and can collect or hold them. But the statute just seems to say, it seems to talk about human remains in a grave in very different terms, right? That they are not held or possessed by someone until they are unearthed. Is that a
Well, those are
correct
different
approach
provisions.
to
You're
the
speaking to
statute?
3002, which goes to ownership. We're talking about here now, well, to back up,
Well,
there
I
can be
think I'm trying to interpret what you were saying, that you were saying no one can look at the remains when they visit the cemetery, no one can, and I think I agree with you in the sense that it's not the original purpose, right? Why were these children brought to the school? They died there. Why were their graves moved, et cetera? But the question instead is, have the remains been accumulated? Have they been, and the only way to get the remains is to disinter them.
Well, it hasn't been done. They
Right.
haven't, the remains have not been accumulated. But
they
museums,
were-
for example, do accumulate remains, and they,
Right.
for example, preserve them, and they display them. And if they haven't displayed them immediately, they put them in airtight locations away from the light, so they are preserved and conserved, so they can be studied at some future time or exhibited. That's not been done here. What was done was, when the students passed away, they were buried, they were interred. There is no gathering, there's no purpose
Then they were
associated with it.
disinterred.
Then they were disinterred, and they were moved to another location where they were again interred. They were buried. They were not displayed. They were not shown. They are now in a cemetery. None of that is consistent with gathering objects for the purpose of researching or showing or studying them. Nothing has been done, and the Army has had no purpose, and the complaint alleges no purpose of the original burials or the secondary that was for purposes of exhibition. The relocation took place in 1927. Whatever's been alleged now in terms of what's happening in the recent history at the barracks is simply that there's a sign in front of the cemetery. There's not an allegation of how this gathering or accumulation allegedly occurred. And there's not a purpose. There's nothing in the complaint that says that the purpose in 1927 was to exhibit these remains. Nothing associated with what has happened with these remains thus is consistent with any of the definitions of holding or collections. But I just ask the court to understand that we are trying to explain and follow the statutory language, which is simple as they said. It's a repatriation process that's set forth in 3003, 3004, and 3005. That's what
Of course,
speaks-
3005 says not included on an inventory, and we can read in, inventory means inventory of holding or collection, but your argument is asking us to interpret the not to mean not included on the inventory, but should have been, right?
Well,
Not included on an inventory, but is in, a holding or collection.
It doesn't even need, you don't even need to finish that awkward sentence about not included in such an inventory. What's important about that provision in A4 is that there are two categories of remains, one for which cultural affiliation has been established and one for which the remains are not included on any such inventory. What's important about both of those is that they're tied to the inventory provision. Congress didn't say remains for which there's a cultural affiliation and then everything else. It tied it to the inventory. Both are tied to the Section 303 inventory, which makes sense because this is a sequential process. Museums and cemeteries have to do an inventory for certain remains. That becomes the universe of remains with which we work. Section 304 says, for objects, not human remains, you do a summary. And then 3005 harkens back to each one. 3005 harkens back to the inventory in Section 3003.
Well, Ms. Wright says these children died buried in 1927, and they can't produce the affidavits of the next of kin. How are they ever going to be able to repatriate the children under your interpretation of it?
Those are separate, entirely separate. The statute is one thing, and it doesn't. What's being asked of for return under the Army's regulations, which is separate and apart from NAGPRA, from the statute. That's separate, and the Army has said, if you don't want to take the NAGPRA statutory route, there's a regulatory route you can choose if you want remains returned to you. And that's the one that requires the signature of the closest relative.
If that's the Army regulation, they can't comply with it, so they have to go through the statute.
Well, Your Honor, both the statute and the regulations have certain requirements and conditions, and if an entity can't fulfill that, that's something I can't speak to. But the regulation is trying to prevent, for example, just anyone saying, I want those remains.
Oh, I don't
I'm not a
dis-
relative, but I want the remains.
And I do not disagree with that. That would be a wholesale problem for the United States. But in this particular case, what I was trying to figure out, well, here's a cemetery that's been, is advertised is the wrong word, but I mean, it's out there for people to view and encouraged to see that there were children that were in this school system back in the late 1800s and 1900s. They died, they're buried here. The tribe wants them back. And
Two things. There are two ways they can get them back, either by the statute, and Congress has just simply put in conditions and limitations and criteria. And that's what we're stuck with. And the Army has no authority to disregard what's in the statute. In terms of the regulations, it's another option. It's an option that the tribes can seek. I would just like to say. Go ahead.
I don't want to cut you. Finish your point, and then I'll come back.
I'd just like to say that there's no allegation in the complaint, though, that there's any affirmative sort of encouraging people to come and look at the cemetery. But I also offer that doesn't the complaint allege that it's like on the website or something, that the cemetery offers visitors a glimpse into the unique past of the United States and Native American history? I mean, I feel like that is inviting people to come look at the graves. We accept the allegations as they are, but what I offer is what the Army is doing is acknowledging that on its barracks, there is a cemetery where these children are located. If it can be that the Army just takes the sign down, but it most certainly is not.
Well, this is here on a 12B6, so as Judge Harris pointed out, why isn't that sufficient to get by the 12B6 motion? As to, that is pure, the 12B6 is purely on the pleadings. So why did that allegation get them by the 12B6 motion?
Why that allegation?
Why does the allegation that she read to you not get them by the 12B6 motion?
Oh, well, in part, it's simply because it's a naked assertion, and this court has recognized in Cortez that a naked assertion that's devoid of further factual enhancement isn't entitled to credibility. But I will let's just assume that what they say is properly pled. The point is that the government is simply acknowledging the presence of these remains. And in many ways, I shouldn't speak personally, but I think it's a good thing that the government acknowledges that they're there. The other options we ignore. We ignore that they have existed. We ignore where they are now. But there is nothing in the complaint that establishes that either in the first instance, when these children originally died, that their remains were gathered and accumulated for the purpose of exhibition or research or study. And there's nothing in the complaint that establishes when they were relocated that the government did anything but just inter them again.
Can I take you back to that act? Because we are on 12B6, which would seem to say, only if the statute, if there's no way to win, right? Does the act say anything about the control or who has control of buried human remains?
Not for purposes of repatriation.
I mean, anywhere in the act.
Well, Your Honor,
is that saying who has a right to control still buried human remains?
Still buried. I do not believe
I didn't
so.
see anything. I mean, there's provisions about if remains are excavated, if they are discovered, which has a regulatory definition, which means excavated without permission. If remains are disinterred, then there's a provision that explains who has control of that. There's detailed provisions about who has a right to possess those or control those. And then other sections of the statute have to do with remains in, like we've been talking about, holdings and collections, right? Which, they are held by a museum for the reasons we've been talking about. And it explains who can control those, who can possess them, who has a right to request to have them back. I didn't see anything in the statute about who has the right to control human remains that are still buried in the ground.
I don't know of any such provision, and it may likely be because that speaks to, if you will, a cemetery in which individuals are interred.
Well,
And
it's
so-
silent, right? And
Yeah, well, indeed it
if
is
Congress
silent,
is
yeah.
silent about something, we presume that they had nothing to say about it, right? And if the statute's silent, it doesn't create an obligation.
Well, I mean, I think that your colleague's response, and I do want to give you a chance to respond to this, is it's covered by 3005A because the remains are possessed and controlled by the federal agency, and that the way this is supposed to work is under, let me make sure I get this right, under 3005A1, those are cases where remains have been disinterred and are part of a holding or collection now, and in those cases, the burden is on the government or the museum. Do an inventory, your burden, inventory it, try to figure out cultural affiliation, and give the appropriate notifications. And if 1 and 2 don't apply for whatever reason, including they're not part of a holding or collection, then now the burden is on the tribe, and under 4, they have to come in and establish cultural affiliation, and at that point, they get repatriated to the tribe. Why isn't that what the statute says?
Well, under 3005 in its entirety addresses the universe of human remains that are subject to repatriation, and that's established in 3003
Wait, I'm sorry, just say
3004.
that again. 3005 in its entirety applies to what?
Speaks to the universe of human remains that's already been defined by 3003 and 3004.
I don't see that.
That's, if you look at 3005 A1, A2, and A4, all speak to either section 3003 or 3004.
Right, but I don't understand that to me doesn't answer the question. A says, and I understand you think the heading is wrong, we should ignore the heading, but A does say, this thing speaks to human remains and objects possessed or controlled by federal agencies and museums. Sometimes the burden is on the person or the agency or museum that has these remains as part of a holding or collection, inventory it, figure out cultural affiliation, and make notifications. And then under 4, as I read 4, it's just saying when subsection 1 and 2 are inapplicable, now the burden is on the tribe. The tribe has to come forward, show cultural affiliation, and at that point, the remains are repatriated. I understand your argument that this is, you have a different reading, but this doesn't strike me as like a model of clarity or disambiguity going your way, especially because you do have to say the heading is wrong. When
No, you don't have
Congress
to
said
say
what
the
this
heading is
speaks to.
wrong. And we've never said the heading was wrong.
Okay, then
It's
how come
simply-
it seems to say it covers all objects possessed or controlled by federal agencies and museums, all human remains?
That is indeed what the heading says, but this court has acknowledged that what's in a heading doesn't limit the actual text of the
I'm sorry,
statute.
I said is wrong.
So
Right.
the question is.
Inartfully drafted. It
it-
should have said holdings and collections.
Fine, so the question still, the court has to recognize that nothing in the text of A4 speaks to possessions or possession or control. So the question becomes, and the government doesn't dispute that possession and control is an
Let me
element.
just so I truly don't quite understand what you're saying about subsection 4. Would your argument be different if subsection 4 had simply said something like, in all other cases, or where subsection 1 is inapplicable, then Native American human remains shall be expeditiously returned where the requesting Indian tribe can show cultural affiliation? Does your argument depend on the fact that they actually said the words not included on an inventory rather than where section 3003 is inapplicable?
Well, it would be much clearer, and we couldn't rely on section 3003 if Congress said Section 3003 is inapplicable.
So okay.
It's just that Congress clearly harkened back to 3003 and defined human remains in A4 only in terms of the inventory in Section 3003.
It doesn't say that. It just says they're not included on an inventory.
Inventory, what inventory is Congress speaking of? The inventory in
The
Section
inventory that didn't
3003.
get done because they weren't part of a holding or
It doesn't say the
collection.
inventory wasn't done, but it still harkens back to 3003. We can't extricate 3003 from the interpretation of A4.
Well, of course you can't, because the obvious point, I think we all agree that where 3003 is not applicable, like as part of what Congress is saying, you're saying that Congress is specifying that the reason it's not applicable is because it should have been on an inventory, but it wasn't.
I'm not saying that, I don't think Congress is saying that it's inapplicable. If Congress was saying Section 3003 is inapplicable, it most certainly would have said that. Because the only reason we have an inventory to speak of in 3005 is because the inventory is required as part of the repatriation process pursuant to Section 3003. And the point I'd like to make about the heading, I understand the heading's there, and we're not disputing that part of the definition of criteria for remains that qualify for repatriation includes possession and control. But it's not because we drag it from the heading, it's because it's in Section 3003. It's because Section 3003 says holdings and collections over which a federal agency has possession or control. It's a package, if you will, of criteria, and as I said, it's the universe of criteria that apply.
So if 3005 A4, this little clause about, not on an inventory, if we interpret that clause to, without saying it in as many words, to actually mean and all cemeteries where remains are still buried, right? That's what we're doing. We're reading that to mean all remains, or that's what your opponent wants to do, is to include cemeteries. Then we would have to go through back to 3002C, right? Because Congress specifically limited the intentional removal from or excavation of Native American cultural items, which includes remains in the definition. Removal of such items is permitted only if, and then they lay out 4 requirements, right? And so you have to, obviously you have to intentionally remove or excavate those remains before you can repatriate them. So you seem upset. I'm asking something that I think you're going to want to agree with. Just going to give you the answer before you respond. I'm baffled we have these requirements that we would have to go through, is my point, for human remains that are still buried, that these requirements don't apply to excavated remains and cultural objects because they're already out, right? But if we're going to interpret this clause in 3005A4 to kind of backdoor in any cemetery without, consent, then we have to apply 3002C. That is a really complicated question. Do you understand at all what I'm saying?
I believe I do not, but I.
That's fair.
Any non-poker face where I'm showing emotion is because as I understand, and I just realized 3C was cut off, but 3002 goes to ownership, and it goes to a particular time frame, which is after the passage of the act. So.
Right. 3002A is about anything that's excavated or discovered after the act, right? And that's what you would be doing. You would be excavating these
Correct.
children's remains
Correct.
after the act.
Correct.
Right? And then C says you cannot intentionally remove remains from the ground unless you do these 4 things. It has requirements for that. That would apply here, wouldn't it?
Your Honor, I'm so sorry, I cannot speak to that because the title of this is ownership, and it doesn't speak to repatriation as I understand it. As I said, I understand that process to be the 3 sections I've spoken to.
Right, but just like kind of practically, right? You can't repatriate human remains unless you disinter them?
Well, yes.
Okay. And Congress is limited when they can be disinterred.
Yes.
Thanks. Sorry.
All right, well, we have taken you way over your time. Apologies. And Ms. Wright, you have a few minutes for rebuttal.
Thank you, Your Honors. I just have a few brief points. First is that NAGPRA was enacted to address a specific problem, and that problem was that it was federal agencies and museums who were deciding what could be done with Native American human remains when it should have been the lineal descendants or the Indian tribe. Here, the federal agency buried the remains without consent, dug up the remains without consent, and reburied the remains without consent of any of the families or the tribe. And NAGPRA was enacted to ensure that Native American human remains could be returned to the tribes in those scenarios, not just because returning remains is important, but because returning remains allowed Indian tribes to bury the remains of their relatives according to specific customs and traditions. And by federal agencies' possession and control of remains, this necessarily meant that Indian tribes and lineal descendants were denied the ability of providing their relatives' remains the dignity and respect of a proper burial. And that's what Winnebago seeks here, the return of Samuel and Edward, so they can finally be laid to rest at Winnebago.
Well, let me follow up one other thing. We do know from which tribe these children came, and we do know they went to the school, and we do know they died there, and we know they're buried where they're buried.
Yes, Your Honor.
Can I give you a chance to address Judge Rushing's concern, I think, with your position that it would, if we read 30054 to include buried remains or remains in cemeteries, that would trigger 3002 and its requirements for disinterment. Do you want to address that?
Sure, Your Honor, I can briefly address that. The requirements under 3002 for disinterring Native American human remains simply are that it be done in consultation with the tribe, that the remains be given to the tribe with the closest cultural affiliation who states a claim for the remains, and that proof of consultation is given. And so there's nothing in 3002 that conflicts with an obligation to return remains under 3005.
It just strikes me as odd in the way that the whole act hangs together, that there are these separate sections about human remains in graves, and limits on disinterment, requirements for what to do if they are discovered or excavated, and then there are separate provisions about remains that are held by museums, right, in a holding or collection. That whenever Congress is talking about human remains in graves, it is first mentioning excavation, removal, disinterment. And there's no provision that creates an obligation to do that. The overriding principle seems to be we're not doing that. If that happens by accident or happens with a permit, here's who owns it, here's who controls, possesses. But that there's, the way that Congress is talking about remains in graves is pretty different from the way it's talking about remains that have already been disinterred and are on display in museums. And if they meant to kind of hide in the mouse hole of this clause in 3005, this significant obligation to dig up the cemeteries, it seems like they would have mentioned that.
I see my time is about to conclude. May I briefly respond?
Feel free to respond.
Thanks, Your Honor. When Congress was enacting NAGPRA, it was responding to a problem that there were 100,000 to 2 million Native American human remains that were possessed or controlled by federal agencies that belonged to the tribes and the lineal descendants.
And those were not graves, right?
It was just the breadth that there were potentially millions of Native American human remains who had not been returned to tribes where they belonged. And so Congress could not specifically delineate every single scenario by which remains that should be returned to tribes, the process by which they should be returned to tribes. It just required mandatory repatriation if a tribe can prove certain requirements, which Winnebago has proved here. Thank you.
Thank you. We would like to greet you if you will come up to the bench, and then we can adjourn court for the day.
This honorable court stands adjourned until this afternoon. God
Oh.
save the United States and this honorable court.